agreement with him. Any mention requiring dates and anything to be fixed, you can decide with the bench, basically with him. And then if any disagreement, just come before me, I'll help you out.
Lordship, I am seeking for an adjournment today. Shall I talk with the courtmaster now?
Adjournment?
Yes, ma'am.
I'll have to.
14.
I'll have to dictate there. You can place before me.
Item number 14, madam.
Learned Counsel, Mr.
W. Ahmed.
W. Ahmed. Okay, you've taken consent from the other side.
I have taken consent.
With the consent of the other side has prayed for adjournment. After vacation?
After vacation, may I pray for a fixed date, madam? Yeah.
Huh? No, fixed date. Actually, the registry has requested me time and again not to give a fixed date. If it's not an urgent matter, it's for of the year 2025 fixed date. Maybe old pending matter, we can give you a date, but not for 2025.
After vacation.
After vacation.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 31 and 32, your lordship.
Okay. It will very 40 color and 14 color. Okay. No. See, I have already heard the matter. I just want to ask whether I will deliver the judgment, reserve it as CAV, or you want to submit something more. Then,
Lordship, the CAV can be done, your lordship.
if you want to submit something more, then
Lordship, everything has been submitted, lordship, by both the
only for one side you are saying, no?
No,
What about the other side?
Then your lordship, can this matter come up after vacation, lordship, or after 1 week? Because both the arguing counsel are not there today, lordship.
After 1 week?
Yes, sir.
All right, after 1 week. So I can reserve it because as I have heard the matter, I can reserve it as CAV and then I can pass the judgment. So earlier I thought of framing substantive questions of law. Actually, it is not required. If both are heard together, then I can pass the judgment and it will be helpful for both the cases.
Problem.
14 question, no?
Meet please your lordships. With the
1 week code, you know. Even as 31.
Meet please your lordships. With the consent of the other side, I beg to mention item number 21 of the dealing list, your lordships. Kindly the matter may be taken up after vacation.
After vacation.
I am for the appellant, your lordships.
Learned Counsel, Miss
S. Sharma, on behalf of the appellant.
On behalf of
Appellant, your lordships.
for the appellant with the consent of the other side has prayed for adjournment. On behalf of whom?
Your lordships, the conducting counsel K.K. Bhatto.
On behalf of Learned Counsel, Mr. K.K. Bhatta, with the consent of the other side has prayed for adjournment.
May I pray? So I beg to mention here item number 27 of today's list, Lordship. Here, Lordship, I have lost contact with the appellant, Lordship, and they are probably required one application to file as a substitution application, Lordship.
Okay.
So here, Lordship, only one thing, Lordship, I have lost contact, so I will be allowed to withdraw my wakalatnama, Lordship, and registry may be directed to issue notice to the appellant, Lordship.
Without an application, you file an application to withdraw the wakalatnama?
And in that case, the matter will be adjourned for a week, Lordship.
Okay. Learned Counsel, Mr. A. Ahmed has prayed for adjournment, leaves the matter after 1 week.
May it please your lordship. Your lordship, with due consent from other side, I beg to mention item number 25 of today's list, your lordship. I am for the appellant, your lordship. My prayer is that it may be taken up after vacation, your lordship.
Lordship, I am appearing for the claimant.
Learned Counsel, Ms. P. Bothakur, with the consent of the other side. Learned Counsel, Ms. P. Bothakur is present for the appellant and Learned Counsel, Mr.
K. Alam.
K. Alam is present on behalf of.
Claimant. Respondent number 1 and 2.
But your name is not in the cause list. You are on behalf of your senior.
Yes, sir. Yes.
Who is your
A.
senior?
Hussain.
Huh?
A. Hussain.
On behalf of Learned Counsel, Mr. A. Hussain is present and has represented respondent number 1 and 2.
Yes, sir.
List the matter after vacation.
Date may be fixed. Date may be fixed.
May I please, Your Lordship? Regarding item number 27, my lord, and understand it's taken time, my lord. This matter, my lord, appeal, my lord, already abated, my lord, because more than 1 year back, the appellant died, my lord. we are facing problem because of the stay order operating, my lord. So appellant also not taking any steps, my lord. We are suffering, my lord. Even, my lord, my respondent, she is also, my lord, very old lady, my
Probate
lord.
case.
Probate case, my lord. So only one observation required, my lord, that appeal is abated, my lord. Nothing more, my lord.
But for that also, I have to obtain
No,
instruction.
no, it will have a bearing on the
Yes.
legal heirs, no?
Legal, yes, but they are already abated because one,
I'll have to go deep into it. You see,
Only
there's a
because-
probate case and then the.
because
legal-
if they file, because if they file any application for setting aside abatement, then it can be restored to file. There is no problem in that. But
No,
because the stay order is operating, that is,
Just, we'll take up the matter then. We'll take up the matter and we'll hear you.
yes, only that much, nothing.
Maybe after a week.
Here only difficulty is that I do not have any instruction from my client. So
maybe
I have
after
to
a
withdraw
week,
my
only
wakalat.
one-
Yes, madam, any date may be given, kindly,
Date
madam.
video gitu. Last week of TV. 22nd September.
I'm deeply obliged.
Because it may be relating to land, house, you never know, no?
Yes, on the property, madam. But
What is-
I'm on the law point because,
I'll just.
yes, nothing on,
I'll
nothing
just
much
check
I
the-
want,
I'll
madam.
just
Just-
trace back the case to its original form and then I'll
Yes.
pass an order.
It was decreed in our favor, madam. They are appealing. That is why their stay is operating and we are suffering, my lord. And
And
Yes.
appellant has already passed away.
If the
Yes.
person is not there, how I can obtain instruction from his legal heirs?
Let
That
him,
is the
let
difficult.
him, let him place his withdrawal
yes,
application.
they
Then
can,
that-
He may withdraw.
he may withdraw, my lord. I'm not on him, my lord. Just I'm placing,
Yes.
I'm obliged, my lord.
Yes.
May it please your lordship.
It may, perhaps it will come to orders,
It will be in orders column.
orders,
Yes. We have given you a date also.
not.
May it please your lordship.
But,
Sir, I have a listing of this matter, lordship. It may be
Orders
taken
will be-
to lordship. Case is picked.
Orders. Hearing order. In the orders column.
Case is fixed in the lower court lordship on 15/9.
কিমান আছিলে এইটো item number কিমান আছিলে last 27 in the orders column give you a date to দিলেন
For this. Case is fixed on Monday lordship, so today itself lordship. Then Monday lordship.
what do you want
In the lower court case is fixed on 15/9 lordship.
relating to what
We have filed lordship a petition for issue of alternative for framing fresh issue lordship or alternative issue. That petition was rejected, fixing the case for argument lordship.
argument well at the stage of argument why you filing us for additional issue
Lordship, one vital issue was left out to frame by the court below lordship. We have filed on 5/9 lordship. Registry is failed to list the matter.
the next date is fixed on Monday
Monday
you
lordship.
don't place your argument
It may be taken on Monday lordship.
you seek adjournment
It may be taken on Monday at least lordship.
just a moment date to যেনেকে লাগে দি দিলে হ'ল। The next date is fixed on Monday.
Monday lordship. Motion matter lordship, we have filed on 5/9 lordship. Okay.
হেৰি এইটো হেৰি as last of হেৰি end of the first list of last item.
Please, your lordship. Lordship, I beg to mention item number 22 and 23, lordship. I have already taken consent from the other side only. For the appellant, lordship. Yesterday, the appellant come to my office and engaged us in this case. We are newly engaged counsel, lordship. My name may be not in the list, lordship.
Yes, okay. You have taken consent from the other side.
Yes, lordship.
Learned counsel, Mr.
M. Das.
M. Das has submitted that he has been newly engaged
Yes.
by the appellant and he has prayed for adjournment with the consent of the other side.
Yes.
List the matter after puja vacation,
After vacation. Obliged.
22-23.
May I please, your lordship? I beg to mention for listing one first appeal from orders matter lordship for today lordship. Because urgency is the lordship, in this case, lordship respondent filed one miscase guardianship case before the additional district judge Dibrugarh lordship. Thereafter, the appellant approached before this honorable court, and this honorable court, entire proceeding has been stayed. Thereafter, lordship, suddenly on 13/7/2025, lordship, ex parte judgment has been passed by the learned, trial court lordship. Thereafter, lordship, child welfare community handed over the minor son to the respondent lordship. And since then, lordship, son has been custody of the welfare community lordship. Lordship. But the son's
So, child is in the custody of CWC.
lordship,
How old is the child?
8 years lordship.
Uh,
Lordship, thereafter, lordship, child welfare community handed over the son to the respondent lordship against
Father.
father lordship, against her minor son will lordship. But his half yearly examination scheduled to be held from 15/9 lordship.
So you have to approach that court first. Why here?
Lordship, expertise judgment already passed lordship.
There are other means.
His examination
Within 1 month, you can file the court who has passed the judgment.
lordship.
Within 1 month, you file a petition, the court who has passed the judgment can review its order. Why don't you try? It's very difficult. High Court will not know immediately.
Lordship,
It
yesterday.
will be safer for the child. High Court will not know immediately. The child has to be consulted. You will say the child is against the child's will, but we do not know. We'll have to talk to the child. Then there's a scope to file a review petition before the court who has passed the judgment. Then you can file a petition for vacation of ex parte order also. And for stay also at the same time. Why suddenly you rush to the High Court? Not today. Some other day maybe. You give him the list and he will.
Lordship, yesterday already mentioned this.
When you have the means and when you have the procedure, when you have everything in your favor before the court who has talked to the child, suddenly this court is not aware of the how the child, whether the child will feel comfortable with the with which one of the parent. It's not very. You won't get an immediate order from this court. You ponder over it. I'm giving you a very good piece of advice. You ponder over it. And if you are insist, then he will give you the date. But not today.
His lordship, with the consent of the other party, I have to mention item 24. Item 24.
Learned Counsel Miss
Tinlung on behalf of D. Sharma.
Naam to Hundian. On behalf of Learned
D.
Counsel
Sharma. D. Sharma.
Mr. D. Sharma, with the consent of the other side, is paid for adjournment. List the matter after puja vacation.
Obliged lordship.
May I please your lordship, I beg to mention one RSA. The matter is of 2000.
Why not before me? I have told you, no? Item number 1.
It's the anticipatory bail application. All the other accused persons were granted bail in this case. So lordship, I have for the reference, I have the orders. I was being left out because the matter was dated on 5th of August, but it has not been listed since the bench was not available.
My lord, here, lordship may call for CD, my lord, so that may be given, my lord. Who will show this? Without CD, my lord.
Lordship, the CD already revealed that there is only simple injury, and after perusing the CD, lordship has given the anticipatory bail.
Lordship may call for CD, my lord, so that, my lord, Tuesday or Wednesday, my lord, and police the case.
Lordship may peruse the.
This is the
lordship's
motion.
own order, your lordship.
Whatever maybe, my lord, their rules are different, maybe, my lord.
Where is the FIR?
The FIR is at page 13, your lordship.
Please read.
With due respect, it is to inform you that on 7/5/2015 evening at about 4:30 PM, together with my colleague battalion, I was on election duty as police sector in 150 number Lagaon Gram Panchayat at Beldola ME School. After the voting was done, I asked the people to leave the gate. But the below name mentioned person along with some 40 to 50 people surrounded me and beat me on the pretext of the above. The mentioned accused person physically assaulted me and my staff and interfered with my duty, resulting in me being seriously injured, and they pulled my uniform and tore it, and they snatched away my mobile phone by beating me up. They were not silent with this much and entered the polling station and tried to snatch away the ballot boxes. It is hereby mentioned that these persons also tried to threaten the presiding officer for dragging him to vote him in the name of the particular representative, and since I was obstructing them from doing such activities, the below accused person number one along with the other accused persons conspired to kill me, and therefore this attack was being made. Now, Lordship, the name of the accused person that were mentioned here, I have not been mentioned here. Moreover, I was in the polling booth. I was a polling agent at that particular day. Lordship may kindly peruse the real state of the affair that I have mentioned in the para 6. I was a polling agent, Your Lordship, for a particular candidate. At that time of occurrence, I was inside the room of the polling station, Lordship. And no, I was not at all involved in this case. I had been wrongly alleged herein. And the presiding officer under whom I was doing my duty has not also made any objection or any.
CD.
My lord.
Call for the CD. Within this week, we will call for the
Lordship,
CD.
may done interim at least because
No,
his examination is going on, Lordship. He is a student of a BFA, Lord. All others are being granted interim bail, Your Lord. At least interim may be granted, Your Lordship.
No, my lord. Next week I will put it down.
Absolute interim, absolute anticipatory bail has been granted to all other accused person. At least interim may be granted to him, Your Lordship. Till that.
After going to the CD.
My lord. My lord.
The other thing, the other person has been granted anticipatory bail
That
after
is there.
producing the CD, Your Lordship. It has been mentioned in the orders also.
No, this is not absolute.
No,
All are BA, my lord. All are regular bill, my lord.
Interim bill to
it has been
anybody.
disposed of, Your Lordship.
But that is after going to the CD.
Yes, there is,
Yes,
my
Lordship.
lord.
But
After-
you have stated just now that their bail has been made absolute, which denotes that earlier they were granted interim bail.
No, Lordship, they were
But
they were given the absolute bail, Your Lordship,
No.
in that particular order.
yes, after
Yes.
going to the CD.
My lord.
No, I am praying for that, Your Lordship, may be given interim bail to me. At least the other person has been given the absolute bail.
My
No,
lord.
I am checking. This person was not given absolute bail, Matibur Rahman.
My lord.
He was granted this anticipatory bail. He was not granted interim bail earlier. Again, this person, he was also not granted
No, Lordship,
interim bail.
they were not given interim, they were given absolute bail after perusing the CD, Your Lord. That is the
No,
reason why I am
but
asking
if
Your
you
Lordship.
say
Minor.
absolute all the time, then I will think that they were granted interim bail. This is what I will.
I am praying for interim for my case, Your Lord. Because they have been granted absolute, and he is a student of BCom, Your Lord. That is the reason why
How old is he?
he is just 30 years now.
30 years.
Let's say call for short date, my lord. Next week. we will put it
What
down.
is he studying till 30
My lord.
years? Call for the CD, list the matter on.
A short date may be given as
My lord.
18.
18.
I don't know.
My lord, to consider for time being, my lord, I should
Item 35.
Wait, lord. Lordship, on the last occasion, your lordship asked me to furnish the judgment as mentioned in the CRP number, lordship, which I have already handed over to your lordship on the last occasion, lordship, CRP number 102 of 2024. There was a reference in the said order to judgment of the Supreme Court, and your lordship asked me to furnish the same today. That is why it has been fixed today, lordship. Okay. দাদা একটু লবস
I cannot remember. What was your matter?
So matter was there was a delay in preparing the claim petition of 95 delay. My delay petition was rejected. And on the last occasion, Lordship, I furnished one order passed by the coordinate bench of this honorable court, Lordship. And in that case, Lordship, it was held
You want your
6
delay
months,
to
that
be-
6 months delay.
Okay.
And
You want your delay to be condoned ex parte?
yeah, no, Lordship, I filed a claim petition along with a petition for condoning the delay of 95 days. That was rejected, Lordship.
Okay.
And on the ground that I have filed the claim petition beyond the period of 6 months, as prescribed in the section 166 3. Then the claim
MP এখন দিয়া আছে? MEC case.
MSc case, Lordship. And I had furnished one order passed by this coordinate bench of our honorable court. It is there perhaps in the record.
What is your prayer? I put
Prayer, Lordship.
follow. What is your prayer?
Lordship, prayer means I may be allowed to, since it is a beneficial legislation, Lordship, and there is a delay, and in my case, Lordship, the 6 month period will not come because I had lost the FIR immediately after the accident. And in the said order, this honorable court has that, whereas FIR was lost, the 6 month period will not be counted. And when the FIR was lost by the police, it is the duty of the police to send the papers to the Crown Tribunal, and it can be entertained as a claim petition. That's it.
Please read your
Lordship,
prayer. What is your prayer? Please read the prayer.
in the CRP, Lordship. Page 7. Calling upon the responsibility as to why the Easement order dated 25/9/2000 was passed by the learned member MACT Golagat in petition number arising out of miscellaneous shall not be set aside and quashed. I am paying for quashing the that order dated 25/9/2024, Lordship, so that I can file the claim petition, Lordship. And in the order I had already placed, Lordship, our coordinate bench has disposed of the petition in the motion state itself, Lordship, and directed the claimant to.
Where is the impugned order?
Impugned order is at page, Lordship, page 25. My petition was rejected.
Please read the impugned order.
Learned counsel with the petitioner is present. Opposite party Reliance General Insurance represented by its learned engaged counsel. Today's date fixed for passing order on the petition number so and so filed under section 5 of the Limitation Act 1963 by the petitioner Sri Krishnakanta Gogoi, praying for condoning the delay of 3 months 5 days in filing the claim petition. It is stated in the petition that the petitioner has filed the claim petition for the accidental injury of himself. The accident took place on 10/5/2023 on National Highway number so and so at Number Forest, turning Karbi along Assam, and case was registered at Borpothar PS case number so and so under section so and so. The petitioner claimant could not prefer the claim petition within 10/11/2023 as the petitioner was unable to collect the accident information report from 50 at proper time due to his injuries and prolonged medical treatment, and the petitioner has no knowledge about the limitation period, and it's just delay of 3 months 5 days has occurred in filing the claim petition. Petitioner further stated that there is no recess or negligence on the part of the petitioner for delay in filing the claim petition. Therefore, it is paid for condoning delay in filing the claim petition. The OP Reliance General Insurance Company has also filed a written objection under section Order 7 Rule 11, read with section 151 CPC and read with section 166(3) of Motor Vehicle Act 2019. It is stated in the petition that as per the claim petition, it is seen that the victim met with accident on 10/5/2023. The claim petition is filed on 16/2/2024 before the court for consideration. The accident took place on 10/5/2023. Hence, it is an undisputed fact that the said petition is filed after 6 months limitation period with an inordinate delay and said compensation, which is eventually an abuse of procedure and contrary to the provision of prevailing law. The Ministry of Road Transport and Highway, Government of India has already notified those new amendment provision under section so and so by the extraordinary notification dated 25 February 2022, and the central government has appointed the first day of April 2022 as the date of coming into force of this provision. This amendment provision relates to management of motor accident compensation claim as per the Motor Accident Amendment Act 2019, wherein the amendment to section 163 contemplates the limitation of 6 months as to file the claim petition before the court. From the perusal of the claim petition and the document relied upon by the applicant, it is clear that the claim petition has been filed by the applicant after expiry of the period of limitation as provided under section 166(3) of the Motor Vehicle Act 2019. Therefore, it is free to dismiss the petition filed under section 5 of the Limitation Act. I have gone through the case record. It is seen from the record that the petitioner has stated in the petition that he filed the claim petition for the accidental injury to himself. The accident took place on 10/5/2023 at number Forest so-and-so Assam, and a case was registered at Borpothar PS Police Station by PS number so-and-so. The petitioner has also stated that he could not file the claim petition within time, that is 10/11/2023, due to his injuries and prolonged medical treatment, and the petitioner has no knowledge about the limitation period as just there was delay 3 months 5 days in filing the claim petition. It is also seen that while filing the claim petition and the petition for condonation of delay in filing the claim petition, the petitioner has not submitted any medical document to show his prolonged treatment which he was suffering from the date of incident. Mere stating the fact in petition regarding his treatment is not enough to convince that he was not in position to come to the court for filing the claim petition. And another ground for not filing the petition within limitation period that the petitioner has no knowledge about the limitation period is not considerable. Considering the above, I find that the grounds so assigned by the petitioner for delay in filing the petition is found not sufficient cause. Therefore, the limitation filed by the petitioner under the Limitation Act for condonation delay filing the claim petition is then dismissed. Petition should dispose of accordingly. Lordship. The main ground, Lordship, the 6 months period, Lordship, under section 166(3).
The MC case was not registered.
Because of the condonation petition, it was not taken.
Not
After allowing this petition,
It may be registered.
it is registered. Lordship, kindly peruse the judgment which I have just now furnished before your Lordship.
Which one?
2023 SSC online.
Yes.
Kindly come to paragraph number 21. Paragraph number 21, Lordship, your Lordship will find. Here in this case also, Lordship, the similar case, the claim petition was dismissed for that grounds a 6 months period, Lordship. Thereafter, this revision was prepared. And it was here, Lordship, in paragraph number 21. Taking note of all this development, the Supreme Court of India rendered a judgment in Gohar Mohammed that I have already submitted, Lordship. A reading of the judgment goes to show that the police are no more playing a mere role of an investigating authority and stopping with mere parting of information. They are mandated by the Parliament to file reports with the claim tribunal, which should treat the same as a claim petition. The claimants have been freed from the sick list and are no more burdened to search for the document necessary for filing a claim. The duty to report is now the police, and the duty to process the said information given by the police and uploaded onto the website lies on the tribunal. When access is given to the tribunal to an FIR and the other details which have been uploaded by the police, the claimant need not be made to run around or suffer from a fear that his petition is barred by time. It is the duty of the claim tribunal to access the information available to it and process the claim and give succor to the victims. It is not an advisorial system as was prescribed before 1/4/2023 other parts of India before in Tamil Nadu, but today it is a people-oriented justice delivery tribunal. Therefore, Lordship, paragraph 25. A perusal of the rule and judgment of the Supreme Court and the timeline which has been set forth above would clearly show that the claim petition need not be comments only by way of presentation of the petition under section 166. This is clear from the section 166(4), which state that a report filed by the police to the concerned authority, including the stakeholders, insurance companies, and the jurisdictional motor accident claim tribunal should be treated as claim petition. That's it. Now kindly come to place paragraph 28 to 34, 28.
Yes.
Paragraph 28, the parliament in its wisdom has ensured that the helpless victim of motor accident need not be dependent upon stakeholder in court for the purpose of initiating of proceeding. The proceeding itself is initiated on the basis of the report filed by the police authorities. In effect, the petition under section 166 is only a reminder to the court that the police have already filed the detailed accident report containing all the requisite details like the first information report, interim accident report, first accident report, and therefore it has to be take up the said report as a claim petition. In other words, the claim petition is only a reminder to the motor accident claim tribunal to perform its duty under rule so and so of motor vehicle rules and to process the claim petition. In view of the above, it is clear that the cases where any request is filed and accessible by the tribunal, then there will be no question of 6-month limitation arising. The issue of 6-month limitation will arise only in case where no FIR has been registered by police and no report has been sent uploaded. The member of the bar represented that the police are not sending the report and hence there arises a problem. Lordship, here the paragraph number 29 is clear. 6-month time will,
Yes.
and accordingly this petition was Lordship allowed. Lordship, the paragraph 32, the offshoot of the discussion is that on registration of a FIR, a claimant is entitled to present the petition without the fear of being thrown out on the ground of limitation. This would be the correct reading of the present legal dispensation in all cases.
I got your point. This is paragraph 32, no?
Yes, Lordship.
So 34 is that
34, the revision petition also allowed because before that.
okay. This FIR was filed on the same day,
After 2-3 days, Lordship.
2-3 days.
Yes, Lordship.
When was the accident?
Accident on Lordship 10/5/2023
And the FIR was filed on?
and FIR was,
Given me a copy of the FIR,
yes, I have already annexed, Lordship.
which, where?
10, page 10.
Registered, FIR was registered after 2-3 days.
2-3 days.
2-3 days. Page 10.
Page 10. 15/5/2023. Incident was occurred on 10/5/2023 and FIR was lost on 15/5/2023.
After 5 days.
Yes, Lordship. When in our coordinate bench, Lordship, there's 2 judgment was discussed, Lordship, and passed the one order.
Yes,
which
let
I
me
had
see.
that day I had submitted for your Lordship.
Which one?
CRP 102/2024.
All right. You are referring to only one Supreme Court case,
Yes, Lordship.
and in this case, the other cases
Yes,
referred.
yes.
Have you mentioned any reason of delay?
Sure.
Any reason of delay in this application?
Yes.
In which paragraph?
First, my ground is the 6 month period that I have to know.
This is the reason.
Yes, and another I had mentioned that it was prevented by sufficient cause because he was suffering from injury. Lordship. It is there in the petition.
Any medical documents?
Medical document I have not because my main focus on Lordship that 6 month period. Lordship.
But you must submit medical documents. You must submit medical, you should have submitted medical documents. Or to have submitted medical documents relating to the accident. You are about to register a motor accident.
Without submitting any report or medical accident report, my petition will not be, it is there in the petition, Lordship, main petition. This is a petition under section 5 in preferring the main petition, Lordship. In the main petition, it will be there.
You bring the medical documents on record. I'll pass an order. You bring the medical documents on record, I'll pass an order. I'm convinced I'll pass an order. To one IA, you bring the medical documents.
By additional affidavit.
Yes, by additional affidavit, yes. I'll pass an order.
Only fix it before vacation then.
Before vacation, yes. Before vacation, it's at motion stage, then we'll fix it last week of DD. Hard learned counsel, Mr.
B. Haldar, Lordship.
B. Haldar. List this matter on. Then you file the medical documents to an additional affidavit. Don't delay. Item 3 for admission.
Please, Your Lordship, this is an appeal under Arbitration Act 1940. Ensuing order is on case number 87. Case number
We'll hear it finally.
Below, today itself.
Yes.
Today, yes, ma'am, it can.
Because this is for admission, then what is the point of hearing for 2 days? Admission, then hearing.
My lord.
We'll hear it.
This can be
every day.
disposed of even today because, my lord, when the Honorable Supreme Court has decided the core subject, and thereafter no scope for filing any.
It's okay, we'll come to
Yes,
the
yes.
fourth subject.
Yes.
Page 87.
Case 87 is the ensuing order, madam.
Yes.
That is, madam, Miss Arbitration case number 4 of 2025, order dated 23/6/2025. Today is the date fixed for necessary order. Both the parties is represented. The application filed by the petitioner under section 30 of the Arbitration and Conciliation Act 1940.
Arbitration conciliation act lagi ode. Yes. Yes.
1940 has not been considered in view of the order passed in Midday 58 of 2025 filed under the section 5 of the Limitation Act, whereby the delay has not been condoned by this court, and accordingly Miss Arbitration 4 of 2025 has been disposed of. Madam, Miss Arbitration has been disposed of in the light of Midday 58 of 2025. Midday 58 is the condonation for delay, my lord. The fact of the case is in case number case number 68. Case number 68.
Yes. This 68.
68, 68, 68, my lord. 3 number para, my lord. The appellant husband was the sole proprietor of farm MS SR Engineering Construction, which had been secured work order bearing so and so in 1987-88 from the respondent. The work order was governed by the general condition of contract, of which clause 70 arbitration. The agreement involved the farm construction permanent amendment section at Tezpur. The firm completed the work and raised the bill for the same on 18/1/1990. However, as the respondent did not make the payment, the appellant was compelled to request the but kindly come page number 70, paragraph 6, relevant portion, my lord. This is regarding the contract, my lord. Up to 3 to 5, that is regarding the contract. Paragraph 6, paragraph page 70.
Okay.
Page number 69, paragraph 4, my lord. I am start from paragraph 69, paragraph 4. Finally, the 69, yes. Finally, the arbitrator heard the parties and made an award dated 31/5/2022 in favor of the appellant and directing the respondent to pay a sum of rupees 1,33,47,268 with the interest of 9% per annum till the realization. Despite of the proceeding culminating in the award, it could not be published as the respondent had not cleared its due toward the arbitration fees. The appellant felt compelled to file the application before the district judge Sunitpur under section 38 of 1940 Act, seeking discretion to the respondent to clear its part of the arbitrator. My lord, here the respondent did not deposit that arbitrator bill, so that is the arbitrator submitted the arbitration award before the district judge, my lord. Then district judge Sunitpur passed an award on 21/9/2022, directing the respondent to clear the said dues of rupees 47,212. The order further stated that upon the clearance of the dues, a copy of the award shall be furnished to both the parties. It is admitted fact that the appellant received the copy of the award on 22/9/2022. Appellant means, my lord, here the respondent, my lord. Notably, the respondent had neither cleared the balance share arbitrator fees nor did they collect the award by the above mentioned date, and in fact the deposit is check up toward the balance payment for the fee only 18/11/2022, after which it received the notice of filing the award on the same date. On 10/11/2022, the appellant filed an application under section 17 of 1940 Act bearing Ms. number 61/2022 before the district judge Sunitpur, seeking the pronouncement of the judgment according to the arbitration award. That is regarding section 17 of the 1940 Act. They have filed one application and that has been registered at 61/2022. The district court dismissed the appellant application filed under section 17 under the order dated 23/11/22, holding it to the premature filed even after the limitation filing objection to the award could expire. According to the court, the limitation began only on 18/11/2020 when the formal notice of the award was received by the respondent and the application to pronounce the judgment according to the award was filed only on 10/11/2022 when the limitation period 30 days was still running at the said point of time. According to the district judge, the limitations when we filed that objection under section 30 of the Arbitration Act, at that time limitation time was still running, my lord, according to the district judge. Then, my lord, the question the above referred order, the appellant filed a civil revision petition number 138 of 2022 under the section 115 Code of Civil Procedure 1908 before the High Court. By way of informed order, before us, the High Court dismissed the revision and upheld the district court order. The High Court also held that the application for pronouncing the judgment according to the award was filed during the subsequent period of the objection by treating 18/11/2022 as the date as notice of filing the award. It referred to the text section 14 and 17 of 1940 Act as well as 119 of the Schedule of the Limitation Act 1963 to hold that the only formal notice issued by the court will satisfy the requirement of section 42, my lord. that is the that case has been dismissed by our High Court also. Then the appellant preferred an SLP, my lord. And observation of the SLP is in page number 80, my lord. Page 80, para 19.
Okay.
Applying this principle to the fact of this case, it is seen that both the District Court and High Court fell into error that the limitation for filing objection was still running when the appellant filed an application under Section 17 of the Act on 10/11/2022. The formal date of notice of filing the award on the respondent, that is 18/11/2022, holds no significance as they were made sufficiently aware of the awards filing on 21/9/2022 itself. The court directing the respondent to clear the fee was a clear intimation about its filing. Holding otherwise would not only be departing from the petition of this court, but also allowing the respondent to take advantage of this own inaction. Hence, the limitation is to be treated as expired on 22/10/2022, and the appellant application seeking pronouncement of the judgment in the terms of award was valid and well beyond the period of filing the objection on the or to the award. That is the observation. Then conclusion. In the light of the above, we allow the present appeal and set aside the order dated 27/3/2000 passed by the High Court in Civil Revision Petition 138/2022. In fact, the circumstance there shall be direction that the district judge Sunitpur Tezpur to take up the dispose of the Misde 61 as expeditiously as possible, preferably within a period of 5 months from the date of the receipt of this judgment. Honorable Supreme Court referred the matter to the district court to dispose of the matter. There is no direction to reject or to allow to dispose of the matter. In the meantime, when we came to the that picture was clear that limitation will start from not from 18/11, from this from 21/9/2022. We have immediately filed the application for delay compensation petition, my lord. At that time, my lord, arbitration case is pending before the was pending before the Supreme Court.
Limitation from 21/9
21/9, yes, ma'am.
and not from 18/11.
Yes, madam.
Okay.
Immediately after, we have filed the delay condonation petition, my lord, in the arbitration case number 4 of the 2022, my lord. And the order of the my lord, page number 83.
Okay.
That is ordered against our delay condonation petition, my lord, dated 23/6/2025. Today is the date for fixed necessary order on the petition number 1094/2025. Both the parties represented. Petitioner Union of India and another file under Section 5 of the Limitation Act 1963 for condonation of delay of 56 days in filing the objection under the Section 30 of the Arbitration and Conciliation Act 1940. I have heard both the parties on the petition. Petitioner had stated that is our ground, my lord. The sole arbitrator has passed the final award on 31/5/2022 in connection with arbitration case number 01/2019. The petitioner stated that they had received the notice from the Honorable Court on 18/11/2022 and accordingly filed an objection on 16/12/2022. In the meantime, the opposite party preferred a mistake under Section 17 of the Arbitration and Conciliation Act 1940 to pronounce the judgment according to the award dated 31/5/2022. According to the petitioner's statutory period to file the objection against the award expired on 20/10/2022 at the time of limit for the said 30 days started from 21/9/2022. But as the petitioner, it ought to have commenced from the 18/11/2022. Honorable District Judge Sunitpur rejected the application of the opposite party filed under Section 17 of the Arbitration and Conciliation Act premature. Matter went up before the Honorable Guwahati High Court, where it upheld the order of the Honorable District Judge Sunitpur. The opposite party went to the Honorable Supreme Court of India against the order passed by the Honorable Guwahati High Court, whereby the Honorable Apex Court passed an order in favor of the opposite party and held that the limitation period start from 21/9/2022 and not from 18/11/2022, and so going by the time the limitation expired on 22/10/2022. That is, my lord, our ground for delay condonation petition, because the Honorable District Judge and Honorable High Court also observed that limitation will start from 1811, not from 2022. And then, my lord, the Honorable Civil Judge, my lord, rejected our delay continuation petition. In paragraph 1 of the application, the petitioner has made a vague and superficial attempt to justify the delay of stating that it was neither intentional nor due to the laches or negligence, and the delay arose from the exceptional and bona fide circumstances allegedly beyond their control. However, on careful scrutiny, the explanation appeared both the unconvincing and legally unsustainable. But this is not intentional, my lord. Our delay is not intentional because the case was pending before the High Court, before the Supreme Court, and before the District Court. And High Court and District Judge also allowed our petition, considering the delay will be run from 1811-2022, my lord. And accordingly, on the basis of this order, the Honorable Honorable Civil Judge Sunitpur also dismissed our arbitration petition under Section 30 of 1940 Act, my lord. Here, my lord, my submission is that, my lord, at the time of when the Honorable Supreme Court passed the order, at that time also that case was pending. Before that arbitration case was pending, there was no observation on the arbitration case whether it could be allowed or not on the delay ground. But only Honorable Court directed to dispose of the case under case number 61 under Section 17 of the Arbitration Act. My lord, my humble submission, when High Court and District Judge also allow our petition, at that circumstances, my lord, that the arbitration petition on the delay ground, my lord, may not be, that is not the reasonable ground to dismiss our petition on the delay ground, my lord. And the case of the Supreme Court is basically under Section 17 of, and the case number 61 of 2022, not on that our arbitration cell. So and in the meantime, they have filed one execution case also, my lord. That execution case is still pending, my lord. So my humble submission that, considering the continuation of delay, our arbitration may be allowed, my lord. Arbitration 1930 may be heard, my lord, on merit, because that has been disposed of, that has been dismissed on delay ground, my lord. So, my lord, my humble submission is that, my lord, that may be that, and I have challenged that arbitration, I think, on merit also, my lord. That is, we have merit also in that case also. That is the ground start from page number 11, my lord. This is my humble submission, my lord. There is no direction from the Supreme Court to dismiss the arbitration appeal, my lord, under Section 30 of Arbitration Act 1940.
So who who was supposed to give 1 crore to whom?
We are supposed to give, my lord. We are the, yes.
So why are you not willing to give?
Yes, my lord.
Why are you not willing to give 1 crore?
My lord, because there's a ground for, my lord, because we have stated the ground for, that is, will kindly come to, my lord, page number.
How much
Yes.
are you willing to give? Why didn't the matter get settled in the arbitration forum?
Then I have to,
You were not there.
no, I was there, my lord, but because we have because the party who appeared before the arbitrator was a stranger. He don't have possessed any valid document to appear. He, petitioner in person, appeared before that arbitration, my lord. Neither he was a proprietor, neither he is a proprietor of the farm, nor he is any power of attorney on behalf of he was a stranger before the arbitration. That is the valid ground, valid ground to silence the arbitration appeal, my lord. Because we have stated in our ground of appeal also in page number 11, my lord.
All the grounds are stated in page.
Yes, all the grounds are stated, my lord. From page number page 11, Roman 1, my lord. as we have stated the delay condonation grant as well as that on merit also, my lord, on arbitration appeal, my lord.
May I please, Your Lord?
Yes.
First of all, section 30 speaks about 3 specific grounds. Not about the merit of the case. And in the memorandum of appeal, they have entire given the merit. Kindly come to section 30. Most probably in that book, that section for Act 40 is called.
I'm checking. I don't think so.
My lord, in this book,
Purnahan
in this book, there is, my lord.
Purnahan 9, no? Yep, 9. At 41, 9, yeah.
My lord, that is print out copy of 1940.
This is the new act.
Yes, it is 1990. This is the old act, 190.
Section 30, no?
Section 30, my lord.
Yes, please read.
Grounds for setting aside award, my lord.
We have to review section 35.
My lord. 30?
35. 30 and 35.
Yes.
Okay, yes.
So these 3 grounds only, section 30 application is entertained, not on the merit of the case. Secondly, my lord, an application under section 17 and section 30, only one of those will exist, my lord. An application under section 17 and application under section 30, if filed together, only one will exist, my lord, because it is contradictory to each other, my lord. Section 17 says pronouncement of judgment in terms of the award, and 30 says setting aside. So, my lord, either of the one will exist.
Okay.
Now, my lord, in this case, the arbitrator has submitted the award before the court. Court means principal civil court. And the principal civil court has decided the matter by order dated 21/9/22, saying that so and so has not paid the arbitral fees of the arbitrator, so pay this amount, and the the award is with me. That is, my lord, order dated 21/9/22, passed in Ms. J case number 68 of 22. This was there. Thereafter, they sleeping over the matter till 17/11/22. So I have filed, the respondent has filed an application for passing a judgment in terms of the award under section 17 of the Act. That specifically says that if no objection is there, then court can pronounce it. But unfortunately, the district judge has decided that no, limitation of 30 days will run from 18/11/22 instead of 21/9/22. I have come before this honorable court. This court has also decided the same thing. We went to the Supreme Court, and Supreme Court says no, limitation will run from 21/9/22, and hence their application under 30 is time barred. Time bar. And at the time of deciding, the Honorable Supreme Court has specifically said, at this, that is at page 21. May I read, my lord?
Yes.
The limitation of filing objection was still running when the appellant filed an application under
Page
section.
21.
My lord, 81.
Yes.
The limitation of filing objection was still running when the appellant filed an application under section 17 of the Act on 10/11/22. The formal date of notice of filing the award on respondent date is so and so holds no significance, as they were made sufficiently aware of the award's filing number, filing on so and so itself. The court directing the respondents to clear the fees was a clear intimation about its filing. Holding otherwise would not only be departing from the precedent of this court, but also allowing the respondent to take advantage of their own inaction. Hence, the limitation is to be treated as expired on 20/10/22. And the appellant application seeking pronouncement of judgment in terms of award was valid and well beyond the period of filing objection to the award, my lord. What I have submitted below, either of the one application will exist. Either of the one application will exist, because 17 application exists, that 30 will not exist. If 30 exists, that 17
So
will
what will
not
be the
exist.
end result?
My lord?
If 30 is allowed, what will be the end result?
Yes, then that will be set aside, my lord.
Oh. So if 30 is allowed, and if 70 is allowed?
17 others, then the decree will be passed, my lord, in terms of the award, my lord. This is there. And so Honorable Supreme Court specifically said that my application is valid and they are not allowed to take advantage of their inaction, my lord. So where is the scope for filing condonation? Now, my lord.
Yes.
AR 1967, my lord. In this case, Honorable Supreme Court has decided that at paragraph 8, my lord. Paragraph 8. May I read below?
Yes.
It is clear, therefore, from the scheme of the Act that if a party wants an award to be set aside on any of the grounds mentioned in section 30, it must apply within 30 days of the date of service of notice of filing of the award as provided in Article 158 of Limitation Act. If no such application is made, the award cannot be set aside on any of the grounds specified in section 30 of the Act. It may be considered that there is no special form prescribed for making such an application, and in an appropriate case, an objection of the type made in this case may be treated as such an application if it is filed within the period of limitation. But if an objection like this has been filed after the period of limitation, it cannot be treated an application to set aside the award, for if it's so treated, it will be a barred by limitation. My lord, here, Honorable Supreme Court has said, if you file this application beyond the prescribed period of time, that it cannot be treated as an application. Clear line, my lord. That application doesn't have any entity, my lord, in the eye of law.
Okay.
That apart, this judgment has elaborately discussed on what grounds the section 30 application can be preferred, my lord. In this judgment is also there, my lord. That 88, my lord. Paragraph 5.
Okay.
Married, my lord. On 18th August 1981, the appellant applied for a certified copy of the award, and the application for the setting aside the award under section 30 of the Act was filed on 8 September 1981 under clause so and so of the Limitation Act, as the time for setting aside an award for granting an award remitted for reconsideration in 30 days from the date of the service of the notice of the filing of the award. Hence, there must be filing of the award in court. A notice must be given to the parties considered of such filing of the award in such court, and on the expiry of 30 days of the service of the said notice, limitation for setting aside an award expires. In this case, it appears that the appellant filed a certified copy for so and so, so and so. The appellant received the certified copy from so and so. The application under section 30 of the Act for setting aside the award was made on so and so. Hence, if the date of service of notice of the filing of the award be 30th July 1981, then in the event of that have happened as narrated above, indisputably the application was within time. If, however, the notice is attributed to have been served prior to that, then the application was barred by lapse of time. This word is there, my lord. Not, Supreme Court has not said that this that type of application is subject to condemnation. Has not said. Has said the barred by lapse of time. The word is there, my lord.
All right.
My lord. One more judgment of Madras High Court I will give you.
Yes.
That highlighted part, my lord, that
Okay.
may be. Settle law. So this is my, now where is the scope for filing condemnation? And the, my lord, trial court has rightly observed one thing, my lord. There is a page, my lord, 86. Page 86.
Yes.
My lord, that paragraph. The petitioner excused that the reason were beyond their control is not only vague, but also misleading. Once the petitioner was aware of the filing of the award, there was no legal or factual impediment preventing them from approaching the court within the stipulated period. The reliance on so and so as the date of knowledge is a self-serving presumption devoid of merit and contrary to the settled legal position. It is expected of a litigant to aware of the law not to fabricate their own version of limitation periods. My lord, thereby the learned court has said that ignorance of fact is, my lord, condemnable, but ignorance of law is not excused, my lord. They have, earlier they have said that no, my limitation runs from here, my lord. Now the Honorable Supreme Court has cleared the position. Now they have come with an application. And apart from that, my lord, they are playing delay tactics, my lord. The contract is of 50, 60 years ago, my lord. And they are,
How many years?
my lord,
15, 16 or 50, 60?
56.
32 years.
32 years.
32 years. 3.5 decades is going.
There is a
And they have determined that they will not give the,
1 crore.
yes, my lord. They are determined. Anyhow.
May I submit one?
Please.
Permission.
Now, my lord, hold on. My lord, his submission is that section 30 and section 7 both cannot exist, my lord. And for the first time, he would bring this fact before the court, my lord, that at the time of filing before the Supreme Court, at the time filing before the High Court, he did not bring this fact. And at that time, both my lord petitioner were appeared before before both the case, in that arbitration case and also section 17. Under section 30 and 717, they appeared before the court, before the High Court also, but they did not bring that fact, my lord. And there is no law that both 30 and 17 cannot exist together, my lord. And my lord, regarding my lord time barred, my lord, whatever his submission, my lord, he said that ignorance of law cannot be justified, my lord. But ignorance of law is not in our part, my lord, that is not on the litigant part. But High Court itself says that a limitation will start from 18/11/2020. When the High Court says that we are the litigant is that they are simple litigant, my lord. From and my lord, whatever they have Supreme Court judgment they submitted before the court today, my lord, that they are also there is a statement, my lord, from the service of notice. From the service of notice of the filing of the arbitration award. Here, that fact is not cleared before the court, my lord. Service of notice will be count from which date, my lord? From the date of knowledge or from the date of the service of knowledge? That has been clarified only on the Supreme Court. Then only we came to know that service of that will not count from the service of notice. That will count from the date of knowledge, my lord. And all the cases he submitted before the court, he relied upon, my lord. In all the cases, the fact is that the date of service of the notice. In our case, my lord, the date of service of notice, that is the question, my lord, before the High Court also, before the civil judge also, and before the Supreme Court. And Supreme Court clarified, my lord, then only we filed. And this is not the case, a simple case, my lord. There is a reasonable ground for condonation of delay. Because, my lord, the ignorance of law, my lord, ignorance of law is not on our part also, my lord. Because we are as a simple petitioner is a simple litigant, my lord. Whatever in the act, my lord, from the date of service of notice, my lord, and that is also allowed by the High Court also, my lord, from the date of the service of notice. So in that case, my lord, our delay condonation, that is not the general case, my lord. The fact is something different from the case he relied upon, my lord. So, and there is a merit also in our case, my lord, condonation. So, delay may be condoned in the specifically in this case, my lord, because considering the fact of the case, my lord.
Okay.
My lord, section
And-
17, either this is my submission from the act itself. This is not a matter of fact. This is a pure law, my lord. And secondly, my lord,
And my lord,
the Honorable Supreme Court in this case, what has been decided from the already decided cases, those cases are, my lord, cited in the judgment itself, my lord. Yes, it's all.
and Supreme Court did not observe on that arbitration
I
case also.
have only one point to ponder, that I will decide accordingly.
Yes.
Because both parties are.
Yes, my lord.
Yes, yes, my lord, that can be, my lord. Otherwise,
Yes, my
Your
lord.
submissions are contrary to that point of 4 questions, so that I'll decide.
Yes, my lord. Must of course.
And I need some time then.
my lord, my lord, yes.
Reserve it. I cannot dispose it of today itself.
My lord. Okay. And interestingly, my lord, the application for condonation of delay, that was not annexed in this memo, my lord.
But that is in the
Obliged.
order, my lord, that is clarified, stated in that order, my lord, under section 50.
Oh, I would have searched for it.
No, my lord.
I'll-
no,
I'll-
no,
index.
she
I would
has,
have searched for it in the index.
Yes, my lord.
I have not noted, I have noted down a few pages, but
Yes.
the rest I will search in the index. That's what I thought, but I won't find
But,
it.
but that is stated in that order itself, my lord. Our ground of the condonation of delay, my lord, of 23/6/2025 order, my lord. Must have this.
But Mrs. A. Gayan, learned counsel for the appellant, and Mr. S. Sahu, learned counsel for the respondent, reserved for judgment and order.
Must have.
So after,
Vacation?
after vacation,
After, no, my lord, 24,
24, can it be on 24/9?
24/9.
24/9. Why don't you fix it for local alert?
Not Lok Adalat,
It is, the execution case, it is already in the mediation. And against the same judgment, your lordship. And for report 22, it is fixed, 22/9.
22 is fixed, my lord. After 22.
After 22, any date.
Actually, this is second appeal. Second appeal.
Yes, second.
Under RERA, so 24 will be motion week
After vacation.
after vacation. After vacation.
After vacation.
First week after vacation.
First week.
We can give you a date also, as you are settling the dispute.
Lordship.
Learned counsel, Mr. D.K. Das. D.K. Das.
Not my lord, F.E. Chaudhary.
F.E. Chaudhary is present for the appellant, and learned counsel, Mr.
Yeah, sure.
A.R. Shom is present for the respondent. It is submitted that the parties are contemplating to settle their dispute amicably. List this matter on Harry Puja Pichar date and details.
15.
15th October.
Oblige you, Lordship.
Item number 6.
In this case, I am appearing on the respondent. Also, it is a order 41 rule 11 case. Therefore, my being a respondent, my scope of argument is very limited. Before starting this reading, they have to satisfy, because order 41 rule 11 is that 41 the lordship will be satisfied whether the case is required to be admitted or not. My scope being a respondent, my responsibility is only to submission I can give. Whether the question raised by them after hearing whether that is a substantial question of law involved or not. In this particular case, I have a preliminary objection on a locus standi of the appellant number 1. Therefore, these are my argument was, and my submission is the appeal itself is not maintainable. That is my part. If Lordship satisfied that appellant 1 is not entitled to file and second this appeal, then matter will be in there. Then he had to amend this petition or make a press file, whatever it may Lordship will can decide.
Okay.
May I go or Lordship will Lordship will find that the main second appeal file either from the judgment of and decree of the first court. If one person is not come to the first court, then he cannot come for the second appeal directly. Here, the case in short, the factually is short, that they file a suit before the trial court for suit for khas possession and permanent injunction. Suit for khas possession and permanent injunction. Oh, if any wrong, you corrected it.
I'm not in copy.
Yes, suit is filed for decree of khas possession and permanent injunction.
And the respondent of this case, they file a counterclaim. File a counterclaim. And for the right title interest of the suit land and ownership, possession of ownership right. This counterclaim, they file a counter. I'm very shortly, I will place this. Thereafter, the trial court almost they have 10 issues have been framed, trial court. And one of the vital issue is that whether the appellant number 1, who is the also plaintiff number 1 of the suit, have a adopted child or have a right over the property. Whole thing is a right over the property. And the court come to a finding, definite finding, I will place from the judgment, that Nilesh Agarwala is not an adopted child and he has no right over the land, being a legal heir. That ends there. And that is also said in that issue, it is also said that it is the point issue is affirmed so far petition number, plaintiff number 2 and for the counterclaim, claimant, the respondent. After that, the trial court hold that she is, the plaintiff number 2 is entitled and the counterclaim is dismissed. I file an appeal before the appellate court. Appellate court with a very reasoned order said that I have a right title over the property and the counterclaim, the relief paid in counterclaim is granted. But on that case, they make a defendant appeal. They have not filed any cross appeal or independent appeal against the.
You were a defendant, you filed appeal and then
Yes.
your suit was decreed in your favor.
Yes.
Appeal was allowed.
Yes, allowed. And they have not filed any cross appeal. Therefore, the finding of the first court is remained. And now Lordship is what the first court says. Lordship can directly go in paper book, their memo, page 74. I will directly take the page because I do not want to make longer time. Page 74 there in paper book, paragraph 31. Page 74. Right?
Page 74, no?
Okay.
Okay. Page 74, yes. Paragraph 31, yes.
Paragraph Lordship will find issue number 4. That is whether the Dogadal Agarwala had adopted the plaintiff number 1 as a son to legally valid adoption deed. And therefore, Lordship, I do not want to narrate already what is the and court after and Lordship kindly see paragraph 33 also. Then Lordship will come to the paragraph 33. During the cross-examination, PW1
Yes.
PW1, the Nilesh Agarwala, this appellant, he stated that test license, voter card, PAN card, GST in Aadhaar card, IT return, NRC had a mention of father as Rotonna Agarwala. He is biological father. He all the time he used the name of biological father, but only for the purpose of this case, they use this adoption deed. They say that I am adopted, which is subsequently the code with a detailed discussion of the Hindu Maintenance Act, paragraph 35, and come to a definite finding that this paragraph 39 onward, Lordship to find paragraph 39. Paragraph 39. In the present case, may I read? In the present case, I do not want to go into all these things, they take more longer time. In the present case, the deed of adoption is not a registered document, but is merely notarized. Although it cannot be said that registration of document is must, but this court cannot take presumption of valid adoption as mentioned in the section 16 of the Hindu. That is
Yes.
further, the defendant claimant has been able to prove through admission of the plaintiff number 1 that his age was beyond eligible age of being adopted. As such, the adoption of plaintiff number 1 by Gita Devi cannot be held to be a valid one. Moreover, next paragraph, the deed of adoption mentioned that the third party, that is plaintiff number 1, shall be entitled all movable and immovable of Gita Devi and Agarwala. It is quite strange that a clause which is regarding the entitlement of the property has been mentioned in the deed. However, in order to decide this issue, court take into consideration only essential valid adoption. The issue is decided negative in favor of the defendant and counterclaimant. Now, question arises after that findings, the court come to a finding that and said that the plaintiff number 1 is not entitled for the because he is but plaintiff number 2, who is a biological daughter of the Gita Devi, said that he has some right over the land. Thereafter, the case and our contract claim is also dismissed. We file an appeal. We have raised it in appeal in 2 questions. I'm mentioning here because in this memo of appeal, they have not challenged those question of law, framing those question of law. We said that court itself, that suit is not maintainable because of the fact that it is for injunction. The person approached the court must have a title, and that title declaration is required for declare, must be a declaration to it. And they call for a khas person where admittedly they are not in possession. And we also on basis of a decision of the Supreme Court, which is mentioned in the appellate court, that when a suit is filed, simplicity, injunction simplicity can be filed. But if the question of title is raised by any of the party, then that petition either should be withdrawn or amended, giving a proper. Therefore, otherwise the suit cannot be closed. Secondly, we said that we are basis of a family partition. we family partition on basis of family person. We got the, and possessing less more than 35 years. Is all these things, it is matter of the hearing lordship, it will be in different aspect. I just, the question of substantial question will be raised. Therefore, I placing this factual part as a short to the lordship. And they file this appeal. And plaintiff number one, whose right has already been assumed, has no locus. Now he is an appellant, and he filed the affidavit. He filed an affidavit, being a power of attorney of the plaintiff appellant number 2.
So according to you, this
Appellant number 2, the plaintiff number 2 in the case, he said, file affidavit, but he himself make a party, file this appeal. And this is my preliminary objection. On that, one person who is not the make the findings of the trial court, who is at an attendant, who is not the oppose the appellate court by filing a course appeal or anything, he cannot be directly come for the second appeal. After that is my preliminary submission. After their submission, I will show, Your Lordship, I will submit that whether the substantial question stated in this petition, the memo of appeal, is a substantial question of law. That I will specifically I will clarify, and if Lordship will find that are not substantial question, then Lordship can close this matter today itself. Or if Lordship finds that a further hearing is required, then Lordship, as for order for 14, then matter may be for hearing. Now I give to after that I will make my submission.
May I please, Your Lordship?
Yes, yes.
Lordship, two appellants have filed this appeal before the Supreme Court. Lordship, you cannot see right from the day of inception of litigation, my lord. Plaintiff number 1 had represented plaintiff number 2 as attorney, my lord. As attorney. Plaintiff number 1 has represented plaintiff number 2 before the trial court as well as in appellate court also, my lord. Hence, my lord, this appeal has been filed by the plaintiff number appellant number 1 as the attorney of plaintiff appellant number 2, my lord. Lordship, you cannot to see is 27. 27. Initial 1, my lord.
So right for initiation, plaintiff number 1 was attorney.
Attorney holder. And this power of attorney has not been discarded by both the courts below. And this was not the issue raised either before the trial court or before the appellate court by the respondent.
Okay.
So, my lord, in paragraph 1 of the claim, my lord, before the
Page
trial court,
27.
page 27, my lord. Paragraph 1, my lord. This is copy of claims, my lord, filed before the trial court.
Yes.
Page 27, my lord, last sentence. Plaintiff number is the 1 is the power of attorney holder of plaintiff number 2 as such on the strength of that strength, the firm filed the suit on behalf of plaintiff number 2.
Page
Page 27.
27.
Last sentence.
Last sentence, my lord. Paragraph 1, last sentence, my lord.
Paragraph 1, last sentence.
Last sentence.
Okay, yeah, got it.
So, my lord, this suit was filed claiming right of inheritance from late Durga Lal Agarwala, my lord, over the suit property. Both the plaintiffs had filed the suit. Plaintiff number 1 had pleaded before the trial court that he is adopted son, but adoption was discarded by the trial court. In spite of that, my lord, trial court was pleased to declare the plaintiff number 2 as legal heir of Durgadal Agarwala and
With right title interest.
it is, my lord. The title was not sought for before the trial court, my lord. Degree of recovery of possession was sought for within 6 months from the day of disposition, my lord. So, my lord, both the plaintiffs were satisfied by the judgment of the trial court. There was no occasion to file an appeal against that because plaintiff number 1 is plaintiff number 2 is the sister of plaintiff number 1. Trial court has granted relief to the plaintiff number 2 and plaintiff number 1 was satisfied with that effect. And they have not filed any appeal.
Cross appeal.
Hello?
He's stating about cross appeal.
No, cross appeal was filed. Now, lordship, against the judgment of the trial court, the present respondent had filed appeal. Now, my lord, your question of Lucas Cindy has been challenged before this honorable court. Your lordship, I can see page number 101 in Excess 7, my lord.
Page number?
101 in Excess 7. This is appeal filed by the respondent before the appellate court below, including present appellant number 1 as party therein. In view of discussion of right title interest of plaintiff number 1, he ought not to have pleaded plaintiff number 1 before the appellate court. He had pleaded. Page 101, my lord, respondent number 1 Nilesh, who is appellate before your lordship. This is their memo of appeal. They have pleaded. So this has given rise of cause of action for filing this appeal, my lord.
He's appellant number 1 in this case now.
In this appeal, my lord. Who was respondent number 1 before the first appellate court.
Okay.
Plaintiff number 1 before the trial court, my lord.
Okay.
So, my lord, this whole, my lord, the plaintiff number 1 is having valid and lawful Lucas to approve this on the court, challenging the legality and validity of the appellate judgment, my lord. Because by the trial court judgment, they were satisfied. Appellate court, by concurrent finding of facts, reversed the judgment of the trial court, my lord. In this case, my lord, the plaintiff have asserted their rights from right by virtue of right of inheritance from their father, my lord. Trial court has held that no, plaintiff number 1 is not the son, but plaintiff number 2 is daughter.
Yes.
Title was declared in favor of plaintiff number 2, my lord. Now, the learned appellate court below, by recording concurrent finding of facts on the basis of a deed of family settlement, my lord, wherein the suit property was not mentioned, wherein father of the appellants were not the party. Taking into consideration of the family settlement, my lord, this degree was passed.
Okay.
Findings are recorded, my lord. Starting from, my lord, page 123.
On family settlement in title appeal, the decree was passed.
Decree was passed. In family settlement deed, my lord, neither the suit property was the part and parcel, nor the father of the plaintiffs were the party. He was also not the signatory.
Page number?
Page number 123, paragraph 25 of appellate judgment, impugn judgment, my lord.
Okay.
123, my lord.
All right.
Page made it, my lord. Para 25. The learned Musib Bokagat has held that there is no material on record to prove that the terms and conditions of payment of rupees 44 lakhs to be paid by Prabhudayal Agarwala, respondent here in your lordship, defendant before the trial court, has been complied with, and the learned counsel for the appellant has argued on that point. Although the argument put forward by the learned counsel for the respondent appears to have merit at the first instance, but on a careful consideration of the family arrangement, it is seen that the payment of rupees 44 lakhs by Prabhudayal Agarwala had no connection with Durgalal Agarwala, through whom the respondent has claimed right title interest over the suit land, my lord. Right title interest has been shortfall through Durgalal Agarwala, but he is not the party to this partition deed, my lord. This has not been considered by the landed appellate court below. Durgalal Agarwala had been given property at Madanganj, Kishangarh, Rajasthan, and bestowed of the property of Madanganj, Kishangarh was independent of bestowing the property at Bogaghat on Prabhudayal Agarwala, and both had no bearing on each other, and were completely independent. Whatever payment had to be made by Prabhudayal Agarwala was due to Rajesh Kumar Agarwala, Gopichand Agarwala, and not Durgalal Agarwala. Therefore, the legal heirs of Durgalal Agarwala cannot claim that the family arrangement is faulty, and on account of fact, an amount of rupees 44 lakhs has not been paid by Prabhudayal Agarwala. Only Rajesh Kumar Agarwala and Gopichand Agarwala and their legal heirs can raise this question regarding non-payment of rupees 35 lakhs and rupees 9 lakhs respectively by Prabhudayal Agarwala for relinquishing their share in the property at Bogaghat, comprising Bajang Mill and Ratanlal Agarwala Rice Mill. As per family arrangement, the property at Madanganj Kishangarh fell into the share of Durga Prasad Agarwala, who is predecessor in interest of the respondents. The evidence of evidence of plaintiff witness, including PW1, who is principal witness in this case, has admitted Durga Prasad Agarwala had shifted to Kishangarh, Rajasthan in the 7th decade of 20th century, and he lived thereon till his death. The daughter of Durga Prasad Agarwala, who has been examined as PW5, has admitted during her court examination that now she owns and possesses Durga Powerloom factory at Madangarh, Kishangarh, after death of her father, and that the same has been put out on rent. The PW1 Nilesh Agarwala has also admitted to the same. Both the witnesses have admitted that PW5 has inherited the Durga Powerloom factory at Madanganj, Kishangarh, after death of Durga Prasad Agarwala. In this context, it is important to look into the family arrangement that was entered into between Gopichand Agarwala, Prabhu Dayal Agarwala, Rajesh Agarwala, and Pawan Agarwala, which clearly reflects that in terms of family settlement, Durga Powerloom factory at Madangarh, Kishangarh was given in the share of Durga Prasad Agarwala, and he continued to own and possess the same till his death, and was later on inherited by his daughter PW5. In this regard, it is quite clear that terms of the family arrangement entered into on so has been complied with and is reflected by admission of PW1 and 5 that Durga Prasad Agarwala owned and possessed Durga Powerloom factory in Madangarh till his death, and the family arrangement clearly shows that he had got it as per terms of family arrangement, my lord. My lord, this family arrangement is neither binding on Durga Prasad Agarwala nor binding over the suit property, my lord, because suit property has not been mentioned in this partition deed. And how this property was acquired, that has also not been proved by the respondent before the trial court. This was independent property, my lord. And that property cannot bind the suit land. So this is a concurrent finding of the effects of landed court below, my lord. Hence, my lord, the records are required to be seen, my lord. It is. This is my submission.
What are your substantial questions of law?
Yes, my lord. I have suggested, my lord, Dr. Bekana to see. Substantial question of law starts from page 19, my lord. As I said, so many substantial questions of law, my lord, but my lord, substantial question of law number 1, 3, and 10 will suffice in admitting this second appeal, my lord. 1, 3, and 10, my lord.
One, three, yeah?
10, my lord.
What?
10 is at page 21, my lord.
Is 19 to
21.
22. Oh. Yeah, yes. My question is not answered. They also admitted that the plaintiff number 1, the appellant number 1 is not a biological child. And the trial court judgment, they have also not said that they have any cause appeal has been filed, what I am submitted. Therefore, appellant number 1 cannot file this second appeal before this court.
No. He was made a party in the.
Yes,
appeal.
party as a what condition? He is as a defendant. As a defendant, title appeal. If Lordship will file an appeal.
Respondent.
Yes,
That's
the
respondent number 1.
specifically that they are as a defendant as a suit. The title is he stated in the cause title. Cause title is showing you the logic cause title. Cause title is said that when appeal will file, the defendant will be that these are the defendant of the original suit. Specifically wrote there.
Okay.
That cannot be rise to right.
He is
A-
named
and-
respondent.
Yes. The plaintiff lordship will file plaintiff lordship will find page
Page 101, annexure 7.
He's been.
Oh,
named
101.
Yes, my lord. He was included in the appeal, my lord.
No, he
And my lord, this appeal is nothing, not a new
No, no,
proceeding.
his
This is
lordship
continuation
will
of the
find
original
the-
proceeding, my lord.
appellant, the defendant, and on the original suit, lordship will find 101. Plaintiff in the original suit. Plaintiff in the original suit. In the that is the cause title. And here the lordship will find if the shown the appeal, there is not any claim regarding nil because claim regarding the it is not true. And he says the recovery person, it is also wrong submission before this court. Lordship will kindly see. I never place anything which is contrary to the record. What is their plain says? Page 27. Page 27. Suit for declaration of first possession. Lordship will find.
Yes.
Suit for declaration of first possession and permanent injunction. Notified. It is not recovery possession. That is why in appellate it is clarified that you cannot claim the right. Now this, if they do not point to one argument of the establishing substantial question of as which is required, but as they want to only place the pleadings in page from the page 19, I will answer the questions. How this question came? If substantial question law is come from the judgment to evaluate the judgment, there is come from. Lordship kindly take one. When I read this thing, I think whether I am this is was a first appeal. Lordship would find even they say the High Court have a no jurisdiction. Total non-appeal. Page 19, Lordship will find substantial question number 1, Lordship they said whether impugned judgment title appealed by the is based on concurrent. What a question of concurrent finding? It is first court. That is the first court.
True.
Total non-application of mine. Second, Lordship will find whether impugned judgment decree appellate court below substantially affect the right of the appellant and plaintiff or not. Can it be a substantial question of law? It is cannot be a substantial question of law. 3. I will answer every question Lordship would find. 3. Whether the impugned judgment of decree dated suffers non-discussing pleading issues repair while recording concurrent findings. How it is concurrent finding? As if they have a copy paste of the another appeal and they put there. How the concurrent finding is not come? Concurrent finding come if two court is a reversal judgment. And the trial court, the appellate court is a question of the trial court. And trial court, how the concurrent finding coming? Now, 4. Question number 4. Whether appellate court is under legal obligation to deal the every findings while the issue of unsetting the decision right. Can it be a question of the law? Substantial question? No law. It cannot be even a submission. Now, 4. Whether, Lordship will find it a very interesting next question. Whether interference with the finding of the appellate court is permissible. Now, Lordship question the Lordship power. He come to before the court for appeal and he himself says that whether the appellate court have permission to have interference it is total non-application of mine, maybe from the other copy paste from the other page. Therefore, this is cannot be a question, substantial question, cannot be framed. Now, next, Lordship, whether High Court in exercise of second appellate cannot substitute opinion, Lordship will find. Can it be a substantial question of law? In contest with the judgment? It is no related with the judgment? Next, Lordship will find. Whether the respondent defendant is merely required to show the decree or the letter, but also show that the adverse effect dependent. Can it be a
He's not pressing. He's pressing on only on 1, 3, 1, 3 and 10.
Huh?
1, 3 and 10.
Kuntu?
Others, I
Not
am-
pressing the other substantial questions of law.
Oh, but if the other question of substantial law is concerned, he have to place before this court substantial question law. And by these pleadings, Lordship will find this question. One by one I have said. Now, what is substantial question? Substantial question of law is a question which should be arise from the appellate judgment. The question of law, the appellate judgment. And here, which the question Lordship will find, Lordship, I am happy to show, which the question raised here is evolved from the judgment. Nothing says here, not a question of law. Buying things, admitting in the appeal, he cannot admit, they may come for a better admission of question of law if Lordship they permitted him to do. If they want, they can find with a better subject question. But how these questions, the question, even the question Lordship will find, the question raise the jurisdiction of this court. This can be, this cannot be.
Question, sir. Only one reply, Lordship. Lordship, before putting as person, my lord, one should be clear enough, my lord, at the time of submission. My lord, my respected senior has submitted page number 27, my lord. This is only course title, my lord. Reliefs are based on the prayer portion. Your Lordship can see page number 29, my lord. Whether declaration of title has been short form before the trial court, my lord. How I can submit that? Page 29, my lord. Prayer portion of the plain. Page 29. Courts are bound by the prayer portion, my lord. If relief has not been short form, court cannot grant. This is the law, my lord. In the prayer portion, my lord, degree 4 position only short form, not declaration of title has been short form. So I have not submitted anything incorrect, my lord. Even I have any copy of plain. To which the Lordship litigation was initiated. And my lord, my lord, I am saying concurrent finding. Learned trial court has discarded the family partition because this was not suit property was not the part and parcel of the same, and even predecessor of the plaintiff was not the party to this deed. But reversing those findings, my lord, appellate court has decreed the counterclaim on the basis of this partition deed. This is question of law, my lord.
Sir, already given.
Or any clarification required, I will give.
All right, yes.
Much obliged.
Maybe I'm come up for clarification also later. But now let me see if I can on my own decide.
Much.
No, এনেকে থাকো পাছত স্লিপ টো মাৰিব লাগিব কাৰণ নাম লাগিব নাই নালাগে পাছত ডিচাইড কৰিম টাইম যদি পাওঁ কৰি দিম আজি
May it please the Lordship. Lordship, the appellants are the, my lord, defendants of the suit, my lord. And the trial court passed the decree. Thereafter, the defendants preferred the appeal. Appeal was also dismissed. But my lord, I just want to take your lordship to the substantial question of law, which I have formulated. Thereafter, I will go to the other parts, my lord. My lord, the page number 6. I am mainly pressing on 1, 2, and 3.
Page 6.
Page 6.
All right.
Well, the first one, well, whether the, what's it got it?
Yes, yes.
Page number 6.
Mm. Yes.
Whether the first appellate court was justified in applying the principles of section 13 and 15 of the Indian Easements Act 1882 when the said act has not been extended to the state of Assam. That is my first, my lord, substantial question, my lord. Second one, my lord, whether the decisions of the learned
Very
courts below
difficult.
recognizing
Not
an
very fast.
easementary right of the plaintiff respondent over the Schedule B suit part under the Indian Easements Act are vitiated by perversity, particularly in the absence of any supporting materials under section 25 of the Limitation Act.
Mm.
My lord, in this case, in this particular, my lord, in the, both the trial court as well as the appellate court, my lord, hold that, my lord, section, the judge's decree was passed on the basis of the, my lord, principle of section 13 and 15 of the Indian Easements Act. Whereas, my lord, in Assam, my lord,
Not in.
that is not applicable. That is the first substantial question of law. And second one, my lord, in regard to, my lord, section 25 of the Limitation Act.
Mm.
Here, my lord, it speaks about, my lord, period of 20 years, my lord.
Mm.
My lord, if your lordship takes up that,
Limitation. Yeah. Logo na logo. ইয়াত আছে নেকি কেনেবাকে? দেখিব।
my lord, my first takes up that Supreme Court judgment, my lord, is that, my lord, the Niranjan Borua and others, Girin Chandra Das versus Niranjan Borua and others.
Niranjan Borua.
Yes, para 17, my lord.
Yes, yes.
Para 17, my lord. Though the Indian Easements Act 1882 is not in force in Assam, there is no dispute at the bar that the principles underlying the provisions of the Act can be applied. Under section 15 of the Act, where a right of way or any other easement has been peaceably and openly enjoyed by any person claiming title thereto as an easement and as of right without interruption and for 20 years. My lord, may kindly mark it, my lord, for 20 years. The right to such easement shall be absolute, and the period of 20 years shall be taken to be the period ending within 2 years next before the institution of the suit. So, my lord, it says, my lord, talks about, my lord, 20 years, my lord, the interruption, my lord, without interruption, they are using that 20 for 20 years, my lord.
It will be 18. Ending before 2
And,
years.
and the period of 20 years shall be taken to be the period ending within 2 years next before the institution of the suit. That means 22 years.
18.
22 years, my lord.
22 years.
Yes, my lord. So, here in this case, my lord, if your lordship takes up the plaint, my lord, lordship will find the plaint at page number. It starts from page 90, my lord. My lord, here, my lord, the issue is, my lord, the plaintiff, he purchased the land from my husband. And while purchasing the land, he was using, he alleged that he was using a land through my land. And thereafter, he says, the plaintiff says that I have, after the death of my husband, I have obstructed him and I have put the barrier on that particular road. As a result, he was not in a position to
come out, to and fro.
Go out of
the
his
thing.
house.
Yes. But here it is admittedly there are other connected roads, alternative routes are there. And he is enjoying that particular, availing that alternative routes. That is the admitted fact, but that part, the trial court and the appellate court never gone into that aspect. And here, my lord, may kindly see page 90, page 91, paragraph 2.
Page 91.
Page 91 of my appeal memo, my lord.
Paragraph 2, yes.
Paragraph 2.
Mm.
I am reading, my lord,
Mm.
that originally the Schedule A land was the property of one Sojal Das, since deceased, son of late Sunil Das, the predecessor in interest of the defendants, that is the of appellants, my lord. On 25/9/1997, the plaintiff purchased and took possession of the Schedule A land from its owner Sojal Das for a consideration rupees so and so by dint of a registered deed of sale being deed number 23 dated so and so. So my lord may kindly mark, my lord, 25/9/1997. He purchased the land and took possession. And my lord may kindly turn to the next page, my lord, next 92, my lord,
Mm.
para 8.
Mm.
Well, I would not like to trouble your lordship in a long hearing, my lord. Just
Yes,
paragraph 8, my lord, page 92.
Mm.
That suddenly on 17/3/2014, at the defendants with malified intention to harass the plaintiff, blocked, obstructed the portion of the suit way which is situated in front of their residence by installing bamboo fencing. As a result, the plaintiff could not access the suit way, are prevented from going out and coming to their residence by using the suit way. The plaintiff had to come and go to his residence by using a paddy field belonging to some other person. The said paddy field could not be used during the forthcoming rainy season. So here he has clearly mentioned, my lord, the cause of action is of 17/3/2014.
That will be
That-
how many years?
Yes.
97, 2007?
Yes, yes, it
But
comes
it is within 20 years.
16 years,
Mm.
5 months, 22 days.
So it's okay.
No, my lord.
Mm.
But here there is a mandatory requirement of 20 years, my lord. Plus 20 years and next another 2 years. Here admittedly, it's
Okay.
16 years. So these are the two main substantial questions.
See, that first substantial question, principles can be used. The act cannot be used.
No, but my
Principles
lord,
can be
but my
used.
lord may kindly see the, I have placed one judgment, my lord.
Mm. See, civil court always, when they are granting easementary rights, the principles is used because we do not have the act here. Act
No.
is not in force here.
But my lord, what had happened in this case, my lord, here, while the tribunal court has held on the basis of section 13 and 15 of the 15 of the Easement Act. Therefore, my lord, that is a
Not on
substantial question.
13 or 14. I think principles may have been used. We'll read the judgment then.
Yeah, no, the trial court held,
We'll read the judgment then.
my lord.
We'll read the judgment.
Yes, I can read, my lord.
The judgment, the appellate court judgment will suffice on that issue.
My lord,
On
may-
that issue,
27,
page 27.
page 27, my lord. That is the submission. sir.
Mm. Page 27. Yes. You'll read or I'll read it.
My lord, page 26, my lord.
Page 26.
Page 26. Page 26, paragraph 15, my lord.
Mm.
It is proven fact that Schedule A land of the plaintiff homestead land of the defendants at the suit way fall under a common plot of land that was stood in the name of Sojal Das originally, and it is firmly revealed that purchased A schedule land is the subject of transfer and plaintiff would not enjoy the benefit that
transfer if defendant did not allow him to ingress and egress through B schedule suitway. It has also been proved that plaintiff had been using the suitway since purchase of the schedule A land until obstruction created. So that means, my lord, from
2014.
yes, from 1997 since 2014. It has also been proved that plaintiff has been using the suitway since purchase of the schedule of the A schedule land until obstruction created. Such right to way of the plaintiff is apparent, continuous, and necessary for enjoying the benefit of the subject matter. So this is the, my lord, this was held, my lord. Defendant has failed to prove any different intention on the part of the original seller, that is predecessor of the defendant, expressly.
But where the sections have been quoted? It has not been quoted.
Next page, my lord, 27, my lord. Hence, reliability on such facts becomes quite doubtful. With the above discussion, this court has arrived at a conclusion that plaintiff has proved that he has a lawful easementary right of way over the suitway for ingress and egress in light of section 13 of the Act.
In light of.
But my lord, that must be, my lord, section 25, my lord, that requirement is not fulfilled, my lord. So unless and until, my lord, section 25.
Maybe that section 25 can be that issue may be raised. That substantial question.
That
law
can
may
be, that
only
can
one.
be. Yes, yes. And any other substantial question at the time of hearing.
But I'm not staying.
But my lord, if the matter is not stayed, my
No, then you show me the area of the land in the plaint. You show me the area of the land in the plaint.
yes. My lord, he is still, my lord, enjoying with the other alternative roads.
No,
And-
when he's using the pothar.
No, my lord.
You see,
No, no,
when
no, no,
he's
no.
using the other alternative
No, no.
pothar in
My lord,
rainy season, we know what happens to the pothar.
No, my lord, right.
You show me the plaint.
My lord, may kindly see the judgment of that, my lord, relevant portion of that, my lord, judgment of the title appeal, my lord. Page 77, my lord.
No, you show me the plaint. I just want to check the area
Yes,
of
yes,
the land.
yes. My lord, it starts from, plaint starts from page 90.
Page 19.
Page 90, 90 of my appeal memo.
Page 19. Only the schedule, I just. want
Or
to check
only the schedule, okay. Schedule A is the land which he has purchased from my husband, my lord.
Entire schedule.
And Schedule A is the land which he purchased. And the Schedule B is the suitway, my lord. Schedule B. A strip, my lord, page 94. A strip of Kacha way measuring about 4 feet in width and 25 feet in length, connecting a gravel subway which lead to the government PWD road. The said road ends at the residence of the plaintiff over the Schedule A land. The suitway is covered by DAG number so and so, periodic patta number so and so.
25 feet, 4 feet. I'll not grant stay.
Then, my lord, may let it be on some other day, my lord. I will come up with other judgments, my lord. I will convince, my lord. I will try to convince you.
Okay. When do you want?
Immediately after.
Vacation? Learned Counsel, Mr.
M. Dottam.
M. Dr. is present. Item number 35, no?
36.
36. M daughter is present. List this matter after vacation.
Obliged.
This petition has been filed, again, a rejection of my two applications, my lord. Final order 13 rule 10 CPC, my lord, by the my lord, executing court, my lord. Now, lordship, to cut short, my lord, this revision, the facts leading to this present petition, my lord, including that petition I filed before the executing court, my lord, that lordship will find, my lord, it will be better if I take my lord to the, my lord, the some basic facts of this case, my lord. So that my lord will find from page 27. So that will enable us to understand, my lord, how this thing happens, why you have filed this petition, lordship will say.
Yes.
Page 27, my lord has got
Yes.
lordship. Now, my lord, paragraph 2, lordship. Para 2, my lord.
There are 2 years.
Yes, that is a judgment in the title suit, my lord, against which appeal was filed. Then it is further carried to the second appeal. Then after the second appeal judgment was there, they filed, my lord, the plaintiff filed an execution proceeding, my lord, start an executive proceeding. So we filed this petition in connection with that executing proceeding, my lord. So how this thing came to this stage, my lord will say, my lord, because the suit was filed by the plaintiff. Other side, we are the defendant, my lord. In that, now lordship will say, para 2, my lord. The case of the plaintiff is as follows. The title of the plaintiff to the extent of 17 biga, 11 katha, 3 chotaks in second RS Patta number 19 of village Labakar Part 1 was declared in title suit number 62 of 1971 on 25/9/1973. And in that suit, all the co-sharers were parties. Thereafter, the plaintiff filed partition case before the collector in which all co-sharers were parties and plaintiff got allotted his share and then possession was decreed to him
Delivered.
of the land allotted. The plaintiff was also given separate patta number 147 for his land in as described in schedule 1 of the plaint. Defendant number 1, see so and so was defendant number 4 in the previous title suit 62 of 71 and 5 biga 18 katan 5 chatak of land in dag number 357 by 388. My lord, here we concern with the dag number 357 involved in fourth schedule of the land, fourth schedule of the plaintiff, my lord. Of the first schedule has fallen in the allotted land of the plaintiff and the possession of which was given to him. After the possession was delivered to the plaintiff, the defendant dispossessed the plaintiff in the middle of July 1972 from the land of second schedule of the plaintiff. This land is within the partition part of the plaintiff and defendant number 1 has no right over the same. The defendant number 2 was the defendant number 1 in the former title suit. An area of 6 katha 2 chatak in the dag number 362 of 389 as described in the schedule 3 was in the possession of the defendant number 2 with a temporary house, and for this reason collector could not deliver the possession by demolishing the house, and in fact the possession was delivered in Azmali. As the land was included in the share of the plaintiff, he is entitled to get first possession of the same. The predecessor of interest of defendant number 3 to 10. My lord, here, my lord, we are concerned because our predecessor interest was implemented in the title suit as a defendant of 3 to 10, my lord. So we are concerned with schedule 4 land that you are coming, my lord. Schedule 3 to 10, Shodalawala Roy Chaudhary was defendant number 9 in the previous title suit. As the defendant number 3 to 10 have houses on an area of 2 biga 10 katha 6, dag number 357 and dag number 388 described in schedule 4, the collector could not deliver the house position of the plaintiff by demolishing the houses. as the land in partition, as this land is in the partition land of the plaintiff, he is entitled to get cash possession of the same, hence the suit. So that is the suit, my lord. Now lordship will.
You are the defendants in that.
But our predecessor in interest, my lord. Our predecessor. Now, my lord, para 3, my lord. Now, defendant number 1, 2, 3, and 5 had contested the suit by filing a joint written statement. No separate written statement was filed on behalf of defendant number 9 and 10. Defendant number 9 and 10 has been filed by their guardian, their team appointed by the court. The contesting defendants have contended inter alia that in their WS there is no cause of action for the suit, and the suit is bad for the non-joiner or necessary parties, and the suit being a continuation of PP case number so and so, the civil court has no jurisdiction to try the suit in view of the provision of Assam Land and Revenue Regulation that the decree passed in title set number so and the allotment made in PP case were obtained by plaintiff fraudulently, and as such the plaintiff is not entitled to any relief on the basis of illegal decree and order. That the second arrest patta number 119 consists of an area of 35 bigha, 7 kata, 11 chotak was previously included in arrest patta number 1963. The original owner of which was Minalini Bose, known as Minimum, who made a will dated 10/11/1982 under which half of the property was given to her adopted son Sudhir Kumar Bose and the remaining half was given to 3 persons, Sushil Kumar Datta, Diptirani Rudra, Elias Arati Chakraborty, Subodh Datta. Each of 3 got 1/6 of the property, and she appointed executor named so and so to administer her property after her death. And in the said will, it is mentioned that there is a plot of land measuring so and so for the charge and for the quarter of the pasture of the charge, and thereafter minimum gifted 1 bigha, 4 kata, 4 chotak of land to Shodalawala Rai Chaudhary by register gifted of 23/4/1948 in arrest dag number 365, which is now included in second arrest patta number 357 of patta number 119. The minimum died in 1949-50, and the executor, Hiralal Biswas, filed miss case number so and so in the court of district judge and obtained the probate on so and so date, and on obtaining the probate, the executor administered the property of late minimum. That the executor gave 16 bigha, 11 kata and 12 chotak of land, excluding the church compound and the village path, and 1 bigha, 4 kata of gifted land to Shodalabara Chaudhary, to Subodh Bose in Pacific boundary, which is sold to so and so, and others, from whom B.K. Rai Chaudhary, the husband of Shodalabala Rai Chaudhary, purchased as described in Schedule 1 of the additional WS. Written statements. Binoy Kumar Rai Chaudhary purchased 18 kathas of land from Arati Rai Chakraborty and 18 kathas from the Subodh Chandra Datta. Thereafter, B.K. Rai Chaudhary died, leaving his wife Shodalabala Chaudhary and others, who became the owner of 19 bigha, 19 katas within the Pacific boundaries as described in Schedule 2 of the additional written statement. Out of 19 bigha, 12 kata, Shodalabala Rai Chaudhary and her son and daughter sold 11 bigha, 13 kata, 6 kotas of land by sale deed number so and so to the plaintiff. The opposite party here, Schedule 3 of the additional written statement and 6 bighas by registered sale deed number dated so and so, defendant number 1 as to defend as described in item 1 of the schedule, and 1 bigha of the land by registered gift deed to the predecessor of interest of the defendant number 3 and 10. After the sale and gift, Shodalabala Rai Chaudhary remained owners of 18 katas, 18 described in Schedule 2 of the additional WS. But the plaintiff, by suppressing the facts and these facts with fraudulent intention, created to sell deed dated so and so for an area of 4 bigha, 8 kata of the land as described in item number 1 and 2 of Schedule 4. Additional WS showing transfer of this land to him by Sudhir Bose, who had previously exhausted his interest. Thereafter, the plaintiff created another fraudulent kabula dated 15 to 1970, showing transfer of the land to him by Arati Chakraborty, and then obtained declaratory decree and allotment order fraudulently. The executor gave 5 biga 11 kata 4 shotaks, excluding the charge compound village path, and gifted 1 biga 4 kata of land to Sodarbala Rao Chaudhuri to Arati Rai Chaudhuri, who sold away at interest by a sale date dated 29/6/61, an area of 4 biga 13 kata 4 chotak to the defendant number 2, an area of 8 kata number 3, but suppressing the fact plaintiff created a fraudulent kabula from the Arati Chakravarti for 18 kathas on 15 to 1970, knowing that his vendor exhausted her interest in the previous sale. The executor gave 5 biga 11 chotaks, excluding the charge compound village path and double lagaisut, and gifted 1 biga 4 kata 4 chotak Sodalwala Rai Chaudhuri to Subodh Chandra Datta, who sold away his interest by sale date dated 15/5/61 to defendant number 2, and by sale date dated 15/5/61 to Sushila, and by sale date dated 17/11/58 to defendant number 2, and then Sodalawala and Rosie Chandra, the others. The executor gave so defendant number 1, he sold 1/3 of the dark number 362 by sale date dated 16/10/1965. The defendant number 1 purchased 6 biga of sale land by sale date dated 21/1/1969. Thus, he became owner of 10 biga, 6 kata and 12 chotaks of land. Defendant number 2 is the owner of 7 biga, 16 kata and 6 chotaks by his purchase date dated so and so. And he is possessing the same by constructing permanent building in one portion. So the plaintiff has no right to deprive the defendant number 2 from his land. The defendant number 3 to 10, my lord. This is our petition. 3 to 10 are in the possession of 2 biga 10 kata of land on the strength of the gift deed dated 1/6/1970 from 1 biga as tenant in respect to 1 biga and 10 kata. For more than 25 years, and they are residing there in permanent house, and as such, they are not evictable. The plaintiff is the owner of the possession of 12 biga, 17 kata, 10 chotaks, and there is no scope for his getting additional area of 5 biga, 6 kata, as his vendor has already exhausted their interest previously. The plaintiff did not get possession of the title of the land described in Schedule 4 of the additional written statement, but he obtained the fraudulent decree by allotment order, and for this reason, the collector refused to deliver the cash possession and asked the SDC to give symbolic possession without disturbing the possession of the second party. So the plaintiff is not entitled to get any relief as suit relief, and the suit is liable to be dismissed, my lord. Now, lordship will kindly skip over, my lord. Now, lordship may come to, my lord, the issue number, my lord, 4, lordship. Page number 52, my lord. Page 52, my lord. Page 52, issue 4, issue number 4.
Okay.
Para 9, my lord. Start from para 9, lordship. It is an admitted fact that in pursuance of the decree passed in 62/71, the plaintiff shares allotted by collector in PP case number so and so, and on such allotment, the suit land described in Schedule 1 of the plain fell in the share of plaintiff. It is averred that in the plain that after allotment of the collector could not give possession of the land measuring land of Schedule 3 and 4 to the plain due to existing of dwelling houses thereon belonging to the defendant. But khas possession over the remaining land was given. It is alleged in the plain that after delivery of the khas possession in the middle of July 1979, the defendant disposed of the plaintiff from second schedule of land of the second schedule of the plaintiff. We are not concerned with second schedule land in the plaintiff. But according to the defendant, there is no such disposes as alleged by the plaintiff. PWD 1 is the plaintiff. He has deposed that in PP case number so and so, the land of second arrest patta number 119 was partitioned among the co-sharer. On such partition, the suit land was allotted to him, and in pursuance of the such allotment, he was ordered to be put in the house possession. He has also deposed that he got khas possession over the allotted land except the land of Schedule 3 and 4. And after delivery of the khas possession, he was dispossessed by the defendants from the land of second schedule. It is seen from the plain that land of the first schedule, including the land of the second, third, fourth schedule of the plain. PW1 has also admitted in his deposition that due to existence of the dwelling houses on the Schedule 3 and 4, the harsh possession could not be given by the collector. He has also admitted in his deposition that defendant number 2 has been living in the land with suit party by suit patta by constructing pakka dwelling house, but PW1 cannot say when the defendant number 2 constructed his dwelling houses on the land. He has also stated in his deposition that defendant number 3 is also living on the land of the suit patta by constructing dwelling house, and Sudhir was living on the land for some time, and thereafter B.K. Rai Chaudhary used to reside in that house. So it is apparent from the deposition that house standing on the land of Schedule 3 and 4 are in existence since long. Exhibit 7 is the certified copy report of the supervisory Kanungo regarding delivery of the possession given in pursuance of the allotment made in PP case number 30-73-74. This report shows that plaintiff was given symbolic possession in respect of the land covered by the second arrest patta number so and so as shown in the trace map. Exhibit 6 prepared by the SK and the cash possession in respect of the remaining land was given to the plaintiff. Exhibit 6 and Exhibit 6.1 are the certified copies of the report submitted by the SK in the connection with the PP case. The certified copies of the report show that due to existence of dwelling house in the land of Dag number 357 and in Dag number 362 Co and Co, delivery of the possession of the same could not be given to the plaintiff, but the delivery of the cash possession over the remaining land was given to the plaintiff. So Exhibit 5, 6, 1 and 7 together go to prove that except the land of Dag number so and so 357 Co and 362 Co, cash possession was given to the plaintiff. Possession was given to the plaintiff over the remaining portion of his allotted land. And at the time of delivery of the cash possession, there are existence of dwelling houses belonging to the defendant over the Dag number 357 Co and 362 Co as shown in the Exhibit 5. So these document clearly lend support to the evidence of PW that he was given delivery of the possession of a remaining portion of his allotted land except the land in Dag number 357 Co and 362 Co, which were described in Schedule 4 and 3 respectively. PW2 has corroborated PWD1 by saying that the defendant number 1 disposes the plaintiff from 5 acres of land and described in Schedule 2 and not concerned the plaintiff by erecting fencing around the same. So it is clear from the evidence that PW2 that the defendant number was disposed of the plaintiff from the land of Schedule 2 of the plaintiff. It is also proved by Exhibit 6, 6.1 and 7 that plaintiff was given cash possession in respect of second schedule of land of the plaintiff, and thereafter the plaintiff was disposed therefrom from the defendant number 1 by defendant number 1. Defendant number 1, DW2 is the Lord Patawari who deposed that in connection with allotment order passed in PP case number so and so, he was deported to the allotted land with the direction to submit report, and accordingly submitted report marked as Exhibit Co. He further deposed that he went to deliver the possession as per allotment. Exhibit Co shows that DW2 found Fakka dwelling house over the schedule of the land, Schedule 3 and 4 belonging to the defendant, and due to existence of the dwelling house, cash possession over the same could not be delivered. My lord. But cash possession over the remaining portion of the allotted land was delivered to the plaintiff. PW2 3 is the defendant number 1. He has deposed that allotment of his share of the plaintiff was made by collector, and after such allotment, collector called a report from SDC. Exhibit Co is the report, and receipt of this report, collector passed order for giving symbolic possession as per allotment paper without disturbing the possession of the second party. And the exhibit shows no is the certified copy of the order. Earlier no shows that collector asked the SDC to give symbolic possession as per allotment papers without disturbing the possession of the second party. The Exhibit 7 proves that in pursuance of the order of the collector, symbolic possession over the third and fourth scheduler loan was given to the plaintiff, and cash possession on respect to the remaining portion of the allotted land was given to the plaintiff. According to PW3, they did not dispose of the plaintiff. According to DW3, he did not dispose of the plaintiff from any portion of the allotted land. But this version of DW3 is belied by the evidence of PWD1 and 2. DWD4 is the defendant number 2. According to him, the plaintiff was not given cash possession over the land which is under his possession. He is possessing this land by constructing Pakka dwelling house. He further deposed that his dwelling houses covered an area of 6 kathas of land which is included in the allotted land of the plaintiff. So it is clear that land on which the DW4 is having his dwelling houses attract the land of Schedule 3 of the plaintiff. It is proved by the evidence on record that cash possession of the land of Schedule 3 was not given to the plaintiff. Rather, symbolic possession was given. DWD5 is the defendant number 3. According to her, she has dwelling houses over the land of Schedule 4 of the plaintiff. So it is seen from the above discussion that in PP case number so and so, allotment of the plaintiff share was made by collector. On such allotment, the suit land was described in one of the plaintiff. Should fell into the share of plaintiff and thereafter has possession over the allotted land, except the land of Schedule 3-4 was given to the plaintiff. It is also proved by the evidence on the record that plaintiff was given symbolic possession and respect of the land on 3 and 4 of the defendant number 2 to 10 were having their Pakka dwelling house thereon. It is further proved by the evidence on the record that cash possession over the land of second schedule was given to the plaintiff, but it is proved by the evidence of PWD that the plaintiff was disposed from the land of second schedule land. There is nothing on the record to show that there is a dwelling house over the land of the second schedule of the plaintiff. Rather, it is evident from the evidence on the record that this land in second schedule is a cultivable land. As it is cultivable land, cash possession delivered by the collector to the plaintiff in pursuance of allotment order. It is also admitted by both the parties that so and so in PP case number so and so, the defender are also made parties. It is also proved by the certified copies of the Jobabandi of RS Patta number 113 marks so and so that the defendants and their predecessors are co-sharers in the second RS Patta number 119. So, my lord, along with them, we are also co-shared in the Patta and the concerned dark, my lord. That I will come to later. So, it can be held that partition was made by the collector among the co-sharer of the Patta. It is also clear from the evidence on the record that making the partition, the collector allowed the defendants who are having dwelling houses on the land of Schedule 3 and 4 to retain their respective possession with their respective building, their own by of giving symbolic possession to the painting over the same instead of giving cash possession. But the collector omitted to fix reasonable rent for the land. As per provision of section 110 of the Assam Land and Revenue Regulation, the collector is required to allow the co-sharer to retain his possession over the land assigned to another co-sharer with his building standing thereon on the condition of paying a reasonable ground and for it to that sharer into whose portion it may fall. So it is apparent from the collector complied with the provision of section 110. So for the retention of the possession of the landowner, land of the another sharer with standing building thereon, but he omitted to comply with the provision so far as fixation of reasonable ground rent is concerned. As per section 110 of the collector cannot give harsh possession by demolishing the dwelling houses, complying with the provision. The collector has given symbolic possession of the plaintiff and thereby allow the defendant to retain possession of the land of 3 and 4 of the plaintiff by their respective dwelling house. So in my view, since the collector allowed the defendant or possessing the land in 3 and 4 with their respective dwelling houses, they are on to retain the possession of the land on schedule 3 and 4 of the plain with their respective dwelling houses they are on. So in my view, collector allowed the defendant or land in schedule 3 and respective dwelling houses. Thus views fortified by the decision reported and so and so. So it is abundantly clear from the foregoing discussion that the plaintiff was dispossessed by the defendant number 1 from the second schedule land, and he was never in the possession of the land of third and fourth schedule of the plain. It is also not the case of the plaintiff that he has given khas position of land of second, 3 and 4, and thereafter he has dispossessed. Therefore, in view of my foregoing discussion, the issue is answered in affirmative. Now, my lord, therefore, my lord, the court has said, my lord, yet directed the collector to my lord, determine a suitable rent to pay it by the defendant number in respect of the schedule 3 and 4 land, my lord. But symbol has position in the respect of 3 and 4 land are not given in favor of the plaintiff. Then, my lord, against that, they prefer the first appeal before the my lord, the additional district judge, my lord. That appeal was allowed. That in that appeal, my lord, I am just cutting short, my lord. In that appeal, the khas position should be given in favor of the plaintiff, my lord. Against that, my lord, we filed a second appeal on the two substantial question of law. This substantial question of law has been answered against us, my lord. Against us, my lord. Now, while deciding the second appeal, if your lordship now look into page 99, 99 of this, my lord.
No, but why should I assess the second appeal?
No, I'm not saying, my lord, the findings of the court, my lord, only. I'm not on that, my lord. I'm not saying lordship, we should lordship review or whatever it is. The findings recorded, my lord, which is important for the purpose, execution purpose also, my lord. This execution proceeding also, my lord. That is why, my lord. Now, shift only page 99, para 20. Lordship will para 20. This is the finding during the second appeal, my lord.
Okay.
Lordship has got, my lord.
Yes.
My lord. From the aforesaid decision of the apex court, it is clear that is the finding of in the second appeal. Clear that exercise of undertaking by the collector under section 54 of CPC for carrying out a partition of revenue paying estate in terms of a civil court decree is ministerial or administrative act, not involving further determination of right of the co-sharers. In the immovable property, contentious issues, if any, arising between the parties, that is important, my lord. Contentious issues, if any, arising between the parties while executing a decree would, however, have to be dealt with by the executing court and according to the provision of the CPC. That, my lord, where the condition, it may ensure, my lord, proper identification of the land, everything, my lord. Lordship is say under section 47 of the CPC, the civil court should decide all the issues in corrective and executability or non-executable decree passed by the court. That is mandated by the law. So which included for them, if there is a dispute with regard to the identity of the land, my lord, because this land, we are all co-sharers, my lord. Now, who is occupying which portion, my lord? So, therefore, my lord, these issues can be dealt with by the executing.
It was already decided.
Yes, my lord.
In the first appeal, it was decided.
My lord.
Against you. In the first appeal, it was decided against you, no?
Which one, my lord?
That 3 and 4, schedule 3 and 4 of the land.
Because schedule 3 and 4 land, my lord, it comprises a huge chunk of land. Not only the land which is covered by schedule 3 and 4. Not only the land, schedule 3 and 4, my lord. It is a huge chunk of land, my lord. Now, if your lordship...
But where your house is situated?
Yes. If your lordship will look into, my lord, page 117, lordship will... 117, no, 118, my lord. Oh, yeah, 102. Yes, my lord. 180, lordship. Annex 7.
Yes.
Lordship will now, here's lordship will find the provision of land mutation information, that is the latest, my lord, will say, Moja so and so third RS Patta number 119,
Hmm.
Dag number 357, my lord. That is reason including schedule 4 land, my lord. Lordship will say under whose occupation land in present, Binoy Bhushan Roy, son of so and so. So Binoy Bhushan Roy is my predecessor in interest, my lord. So therefore, my lord, we file an my lord application before the my lord, learned my lord the executing court, my lord. Let my lord will first I take my lord to 100 and my lord pays 100 and my lord 4 my lord. That lordship will understand how this execution proceeding was started, my lord. Pays 104, my lord.
Yes.
Because after this judgment was passed in the second appeal, my lord, they make an application before this. Made a petition before the executing court, my lord. Now lordship will say the decree holder is represented. 10/4/2025 order, my lord.
Yes, yes.
By this order, I intend to dispose of the petition bearing number 442 of 11 dated so and so and 265/5 dated 19/11/24, which has been filed by the decree holder for vacating the stay order dated 3/2/2007 and for issuing the deed for delivery of the khas position over the decreted land more elaborately discussed in Schedule 3 and 4 of the title suit so and so in favor of the decree holder. The decree holder has pleaded that execution cause was filed way back in 5/10/2005 for execution of the judgment and decree dated so and so passed by the learned civil judge 2 in Kachar, which was later on modified by the learned additional district judge Silchar in appeal number so and so on 2/4/2025, later on confirmed by the Honorable High Court in RSA number 230 of 2005 by judgment and order dated 8/1/2016. The DH has further pleaded that after the filing of the execution petition, the JD approached judgment debtor approached the Honorable High Court by filing a second appeal, and the Honorable High Court stayed the execution, and accordingly, execution case was stayed by order dated so and so. The decree holder has further pleaded that the second appeal so and so was dismissed on contest on so and so date, and the stay order also got vacated automatically on the dismissal of the second appeal. The decree holder has further pleaded that after the disposal of the second appeal, decree holder tried to proceed with the execution. This case for eviction of the judgment debtor and for delivery of the khas position of land more elaborately described in Schedule 3 and 4 of the title suit number so and so disposed of on so and so date. But the execution case could not be proceeded as the case record of the title execution suit 5/2005 would not be traced out in spite of vigorous search. So, my lord, accord was not available. So, the execution could not be proceeded with, my lord. Now, lordship will see. The decree holder has further pleaded that having no other alternative, he submitted the certified copy of the decree prepared as per the judgment and order dated 12/12/1979, passed in the title suit number 76 of 1979. Decree of appellate court prepared as per judgment dated so and so in the title appeal, certified copy of the judgment second appeal passed by the Honorable High Court on so and so date, and copy of the note of the judge in charge copying department indicating that case record of the title execution case so and so could not be traced along with the duly signed execution petition. Reading as above, the decree holder paid for issuing of the writ of possession of delivery of the first possession to the decree land more elaborately described in the Schedule 3/4 of the title suit. Produce the case record hath. On perusal of the case record, it appears that by judgment order number so and so, the learned court had decreed the suit in favor of the decree holder by declaring that decree holder has right title interest of the plot of land elaborately described in Schedule A of the plaint of the title suit number so and so, and by directing defendant number 1 to vacate the position of the land more elaborately described in Schedule 2 of the plaint. The learned trial court, however, had refused to give relief to the decree holder for khas position of the decreed land more elaborately described in Schedule 3 and 4 of the plaint of the title suit number so and so by stating that plaintiff suit for khas possession of the land in Schedule 3/4 is dismissed without cost. Defendant number 2 and the defendant number 3 to 10 will retain their possession over the land in the Schedule 3 and 4 respectively. Then, being aggrieved with the judgment and order dated 1279, the decree holder approves the first appellate court and the additional district judge Kachar, Silchar, by judgment and order dated 2/4/2005, passed in title appeal number so and so, modified the appeal judgment and order dated 2/4/2005, holding that plaintiff is entitled to first possession over the land more elaborately described in Schedule 3 and 4 of the plan by evicting the defendant number 2 and the defendant number 3 to 10. Being aggravate, my lord, now there, my lord, this honorable executing court has, my lord, stated about the second appeal thing, my lord. Now, lordship will find page 108. The decree holder then approves the court for executing of the decree dated so and so, prepared on the basis of the judgment order dated 2/4/2005, passed in the title appeal number so and so in the court of additional district judge Silchar, but the same could not be executed till date, as the case of executing record could not be traced. A decree can be executed on the strength of the certified copy of the decree so and so, and the judgment was passed, but decree arose not sine qua non for execution of the decree, particular view of chapter so and so. As the decree, so my lord, accordingly, the my lord lordship will
So
kindly
this case is pending now.
pending 109, my lord. So he issue a my lord petition was allowed and writ of possession was possession over the decreed loan in 3 and 4, my lord, was issued, my lord. Now, in this execution proceeding, my lord, because that delays in the 2005, my lord, 20 years has gone by, my lord. But no notice, no priority issued to me, my lord, before passing of this order, my lord. When we came to know this, my lord, when the person went to the land, my lord, then, my lord, we approach this honorable executing court by way of a 2 petition that my lord will find at page 110 and page, my lord, 114, my lord. Now, lordship will kindly into page 110, my lord.
Yes.
Because it is admitted that, my lord, execution record, nothing is available. They file simply they file a petition. They have heard only without any notice to us, my lord, at this stage, my lord, and issued an execution court has issued a writ that you go and take the physical possession of the, knowing that, my lord, we are in the physical possession of the property, my lord. No notice, nothing was served, my lord. So in my humble, this goes against the basic principle. At least we should have heard in this issue, my lord. Then in backdrop of that, my lord, we file these 2 petitions. Lordship will kindly see humble petition that is filed under order 13, rule 10 to CPC, my lord. Space 110. Lordship will learn that after getting the information of pendency of the instant execution petition, my lord. Now, by this petition, my lord, why this petition was filed, my lord, that lordship will find that second, the earlier petition appellant in other family member have categorically stated that the Ellis Foot land is their homestead land since 70-80 years. Now, my lord, you will see the admittedly the predecessor of the applicant were not made parties in the title suit number so and so or execution petition, which indicate that it is intentional. No, I am not on that, my lord. Lordship will come to, my lord, the para, my lord, 4, page 111. That as per record of the case, there is no original record of the title suit from which the instant title execution was initiated on the basis of a mere certified copies to cover up the illegality caused in the title suit, and claiming that the record was untraceable from the court establishment and no action was taken against the concerned authority. That as per instant title execution reference to PP case number so and so in connection with DAG number 356, 357/388, so 362/389, 360, 390, 363, 391, so and so, and in partition case, the plaintiff admitted that the Schedule 2 land in his possession except Schedule 3 and 4, and it indicate that PP case was disposed of in the middle of the proceeding as per instance of the petitioner of the PP case and file title suit number 76 or 79 after getting certified copy of PP case number so and so. Thus, it is stated above. Main suit, title suit number 76 of 1979 is untraceable, my lord.
Okay.
Lordship.
Yes.
So on that ground, my lord, we said that this record should be called for the purpose of just decision of the case, my lord. Then, my lord, we filed another petition, my lord. Lordship will pay 114, my lord. That will make it more clear, my lord. Then Annexure 6, my lord, that is also order 13 rule 10(2).
Hmm.
There's as per execution petition filed by the decree holder. So and so is it revealed from that before filing of the title suit bearing number 76, the decree holder filed a PP case number so and so for partition of his share, which was cut out from the second arrest parte number 119 of Pargona number so and so, Moja so and so, out of total of 17 biga 11 kata 3 chotas land. Accordingly, after completion of operation, the said PPK, the DH holder got only second schedule of execution case, and thereafter he filed title suit number 76 or 79, other continuation of the PP case, which he filed to demarcate his share of land, which includes Schedule 3 and Schedule 4. And interestingly, Schedule 4 is the homestead loan with the petitioner applicant, and other where they have been deciding since 1890 years.
No, it's okay, it's okay. See,
My lord.
you have come before this court because you are disputing the,
My lord, my question
You
is
have
this,
one
my
shop house.
prayer, yes, my lord,
You
my
have one
prayer
shop
is this,
house.
my lord.
that judgment there, it was already decided.
Yes, my
that-
lord, only my dismount, you identify the land by virtue of PP case. Then, my lord, you take your share of land. I have no objection, my lord. But my land, which is fallen in my share, my lord, because that land, if your lordship look into the copy of the, my lord, decree passed in the, my lord, I have submitted a copy on the other day, my lord, should be in the record, my lord. If your lordship kindly see the true copy of the decree in the original suit, 76 of 79, I filed a copy of it. The copy is it. Lordship,
Yes.
I may furnish my
Decree in the original suit.
original 76 of no.
Yes.
76. Now, lordship will find Schedule 1 to not concern, Schedule 4, my lord.
Yes.
If your lordship. Dag of 3 number, total land measuring 2 biga 10 kata, bounded by north, remaining land of the Dag, south, remaining land of the Dag. So, my lord, in surrounding, there is land on the Dag number 357 also, my lord.
All right. Let's see here if you can identify, let's hear the other side. If the,
Yes,
if you
my
can
simple prayer, they let them identify because there is a provision, my lord. This include identification of the land also, my lord. In
Because
excess
it
of-
was included
yeah,
in
for
the
all the
judgment
land.
of RSA.
That is, I say, let them go and identify, my lord. If they then simply this can be disposed of like this, my lord. Let them go and identify.
My lord, my humble submission, my lord, my learned friend has read the
20
trial court judgment, my lord. Trial court judgment that was, my lord, considered by the both the courts. And this honorable court, my lord, if your lordship just one para, my lord, I am not going to much more, 102.
So I think on a mutual agreement, you can identify the land and you can.
No, my lord, land can
106.
be identified, my lord. It is not that land cannot be identified. Because it was
Because,
in the
more than
earlier,
that, nobody can go
no,
beyond the
in the earlier
judgment.
partition case also, my lord, it was found that that is my land. That is why, my lord, collector said that.
That is a call for the record, my lord.
Land should be, my lord. Now, I'm coming on. Part 25, your lordship will see.
102.
Ah.
Para
For the
25.
foregoing reason, I am considered opinion that the learned first appellate was correct in holding that section 110 of land revenue regulation will not have any application in carrying out a partition in terms of the decree of civil court. As such, the learned lower appellate court was justified in reversing the finding of the trial court in respect of issue number 3 and 4 and in declaring the suit for recovery of khas possession of the land included in schedule 3 and 4.
In your name only.
Now, my lord, I am coming. Now, these petitions, my lord, whether these petitions are, my lord, bereft of the facts, my lord, your lordship may see, my lord. I'm just. Supreme Court. I'm just. Okay, they are not.
These two petitions in the execution proceeding.
My lord, your losses proceed order 13 rule 10. He doesn't do good.
CPC খন লাগিছিল। ইয়াতেও লগাম।
Uchuk machinery. Uchuk machinery.
My lord, your lordship, yes, order 13, my lord, rule 10. My lord, first thing, this order is not applicable so far execution proceedings concerned as per
Yes,
section
yes.
141.
Yes.
This judgment दिखाया था कौन है? Yes, इसमें देखो तो कोई है क्या है? Your lordship may see, court may send papers from your own records or other courts. The court may also own motion or may in discussion upon application of the party to a suit for either from his own record. Yes. Or from any other court, the record of any other suit or proceeding or irrespective of same. Every application made under this rule, unless the court otherwise directs, be supported with an affidavit showing how the record is material to the suit in which the application is made, and the applicant cannot without unreasonable delay or expense obtain a duly authenticated copy of the record or of such portion thereof as the applicant requires, or that the production of the original is necessary for the purpose of justice. My lord, whether these things are present, my lord, this honorable photo, my lord, this thing, my lord. My lord, in these applications, whether these things are there or not, my lord. This is our High Court judgment, my lord. This is same thing has been written at page, second page, my lord. The last para again, my lord, repeated. Citation something. Year 1996, Guwahati files. That sub-rule 2, my lord, has been quoted again. Sub-rule 2, order 10, order 13, quoted indicates that every application calling for the records of any suit or proceeding from any other court be supported by an affidavit showing how the records were material to a suit in which application was made, and how that the applicant cannot without unreasonable delay or expense obtain duly authentic copy of the record for such portion of thereof of the applicant requires, or that the production of the original records were necessary for the purpose of justice. Well, now, my lord, if your lordship will see at page 110, any statement is there, my lord. Any of the statement is there. As per 100, order 10 rule 13. Well, they wanted to go behind the decree, my lord. My lord, their trial court had not granted, my lord, in my favor, because I am fighting the suit since 1971, my lord. 71 suit had defeated the entire suit. Then, my lord, so far collector is concerned, they did not deliver the position of
Because they cannot.
my lord,
Because they cannot.
they did not deliver because they said that rent should be fixed, should have been fixed. Because in my land, the symbolic position has been given, but khas position did not be given. So that is why I filed a second suit. In the second suit, my lord, the appellate court as well as High Court has granted decree in my favor. Now, can the executing court go behind the decree, my lord?
Cannot. Cannot go.
My lord, this is the my lord.
But
And
that he is not asking for that. He is asking.
no, he's asking for same thing, my lord. He's asking for that. Because if your lordship see the as my lord read the
There's one line in the this.
Yes,
RSA.
contentious issue should
Well,
not be decided by the executing court.
There's one line in the RSA.
Huh.
Any contentious issues
Huh.
can be decided by the executing court.
Huh.
Last paragraph,
Huh.
last line.
Yes.
One line. On that line, he has come.
Could that why that
He
record?
has a short house, I
No,
think.
why that record is necessary, my lord? I am submitting, my lord, order 13, rule 10, whether the requirement is satisfied in these petitions. He can file a petition, my lord, for proper identification of the land. That is another aspect of matter. But whether these petitions are maintainable at all, the learned trial court has rejected those petitions rightly, my lord. These things are not there, my lord, because they have got a certified copy. They could have furnished the copy, my lord.
My lord,
Why?
executing court say
because they
record is
wanted,
not available.
they wanted
Not
to
a
delay the
single record
matter.
is available.
They wanted to delay the matter. Since 71, my lord, I am fighting for this land. And getting a decree is very easy, my lord, but execution is most problem. So can this, my lord, be interfered by the Honorable Court, my lord? Because your lawsuit see the orders, my lord, passed by
It
this.
is at the stage of motion, maybe he wants a stay.
Yeah.
My lord,
Maybe they want a stay. It is at the stage
stay,
of
my lord,
motion.
that is a stay cannot be granted. That is why I am fighting, my lord, here. I want that, my lord, this honorable court may not enter in this petition, revision petition. Because 71 decree, I am not getting the first position till now, my lord. 71, since 71, I find.
So you want me to decide at the stage of motion?
Well, naturally, these are bereft of the order 13 rule 10. These petitions are bereft of order 13 rule 10. They can file certified copy whatever necessary, my lord.
Then record is not available. Where am I getting?
He has
So
got
they said, my
he has got the decree of the title suit 79, my lord, and as well as other decree. My lord,
No,
why
but-
the recording necessary? Because they wanted to delay the matter. My lord, this is not, my lord, my humble submission is this. Your losses may direct, my lord, them to produce certified copy if necessary. But how this thing is necessary, my lord? Order 13, rule 10, they have not complied with. And order 13, rule 10, my lord, that is also not applicable so far execution proceeding is concerned. If your lawsuit see section 141, my lord, it is, my lord, so far miscellaneous cases, it is applicable, not in the execution, my lord. Execution is not applicable. Even if applicable, my lord, they have not satisfied the ingredients of section order 13, rule 10, my lord. Whether, my lord, say the records are material to a suit application is made, nothing has been said. Applicant cannot without unreasonable delay expense obtain duly authentic copy of the record from the court thereof. Well, these are in their hands, my lord. Just to delay, my lord, they have filed this.
Let them say it is my, let them file an affidavit saying everything. Yes, my lord. Oh, no, it is an order submission. I have everything on record.
My lord,
The
so-
trial court order, this I showed to your lordship, that nothing is available. And what my learned friend is saying, that is not available in the way to proceeding, my lordship kindly say.
Trial court
Section
order.
114,
I'm
what it
placing
says.
the trial court order. I'm placing, my lord, your lordship may see, page 119. Trial court order,
Section 100.
119.
That order on the petition?
Yes. Order. First para, my lord,
There are so many matters left. I think this will take some time.
only this, my lord, only this possible. The petitioner, however, has
No,
not.
I'm talking.
Yes, yes, my lord. I'm just only this portion. The petitioner, however, has not assigned any reason as to why the aforesaid records are necessary or what purpose will be served by calling the aforesaid records. Page 119. The second para itself has said, my lord. The petitioner, however, has not assigned the reasons as to why the aforesaid records are necessary or what purpose will be served by calling for the aforesaid records.
Yes,
My lord.
yes.
Then, my lord, your lordship makes. Then page 123, my lord.
Yes, page 120.
123, my lord. As there is a valid judgment passed by a competent court against the petitioner interest of the petitioner, namely Daniel Roy, declaring the petitioner interest of the opposite party decree holder, namely so and so, right title interest over a plot of land, more elaborately described in Schedule 3 and 4 of the petition, and the same has not been set aside by the Honorable High Court in RSA number so and so. I am considered to the genuineness of the right title interest of the decree holder cannot be ascertained by calling for the records of the title to so and so from the so and so. How it will help him, my lord? I don't know.
Even I also see no reason why the records are.
Yes.
required.
Well, records
You
are not necessary.
identify your portion of the land.
Yes.
Why records are?
Who
required?
will, I cannot, my
Records
lord.
have disappeared.
That executing court should do it, my lord, under section 40. That is why we filed it. And what my learned friend is, senior friend has submitted, my lord. Lordship may kindly say 140.
We have the decree, the decree contains everything.
Yes, yes.
We have the decree. We have the decree, both the decrees, copies of the decrees, not the decree, I mean copies of the decrees.
We should do not have all the decree. That is why I call for the papers, my lord. Even the partition papers is also not available. And that was passed 30, 40 years back, lordship will kindly see. And what my learned friend is said, I can, my lord, simply submit, file a.
No, if they cannot find the record, then.
My lord, lordship may kindly look into this judgment also. This was the Honorable High Court judgment regarding order 13 rule 10.
They wanted to delay the matter, my lord. That is why, my lord, this has been done.
Lordship will kindly see, perhaps we or not.
That is whatever judgment is there, my lord. Main thing, ingredients of order 13 rule 10 must be there.
My lord, that
That
has
is
been
not there.
discussed, that has been discussed, my lord. That has been discussed, my lord.
So my humble submission, my lord, that this no court may not have at this stage, my
My
lord.
lord, will kindly
Since 71, I am fighting, I am not getting the possession of the land, my lord. And let them file the documents before the executing court, whatever necessary, my lord.
Lordship will kindly sit. My lord, start from my lord, lordship may kindly look into para 10 of the judgment.
Please read.
I have considered the submission of learned counsel for the parties and also produced the material available on record and discussed about suit is basically relating to the approach or road which according to the opposite party plaintiff is over the land belonging to the petitioner defendant as he is using since 1988, but according to the petitioner defendant such parties does not exist at all. This is the facts of the case, my lord. The petitioner, after closure of the examination of witness of the plaintiff, filed an application under order 13 rule 10 to call for the records of the said proceedings, being case number so and so, my lord, which contains the report of the circle officer to prove the content of the said report. No doubt, after obtaining two adjournment for examination of the defendant witness, the petitioner defendant written statement also pleaded the existence of such report submitted by the circle officer in the said proceeding initiated under section 145 CRPC at the instance of the opposite party plaintiff and also contents of the said report, which according to the petitioner defendant reflect there is no existence of any approach as contended by the opposite party plaintiff in the plaint. Under now, my lord, 11. Under order 13 rule 10, court has jurisdiction to send for the paper from its own record of any court either on its own motion or it is discretion upon the application of any of the parties to the suit. Sub-rule so and so provided the application made to the court supported by the affidavit, my lord, showing how the record is material to the suit in which such application what my learned senior friend was submitting, and that the applicant cannot without reason obtain a printed copy of the record of such portion thereof as the applicant requires, or that the production originally necessary for the purpose of justice. Here all the records are missing. What form will get the copies, my lord? Now, lordship will para 2. Para 12. Order 13 rule 10 does not provide that application to call for the record cannot be filed at the time of hearing stage of the suit. If the application filed by petitioner under order 13 rule 10, no doubt it has not been stated as to why he could not file the said application at the stage where the suitor seeks to take a necessary step before the preparatory hearing or before exam plaintiff witness. The said application also does not contain any statement why he could not obtain the certified copies of the record, whether it is applied for the same. Normally such application, so it required to be filed at the stage when the suit is fixed for taking necessary step before the preemptory hearing, but it is not that an application filed by any of the parties to resolve thereafter cannot be considered, and no order to call for the record can be passed by the court, even if such record is necessary for adjudication of the controversy between the parties effectively and completely, and it is necessary for the purpose of justice on the ground that there is no statement of application. On such application, that authenticated copy of the record sought to be called for or a part of a record could not be obtained without reasonable delay. The court, even in the absence of a statement, can call for the record, so any part thereof, if it is necessary for the ends of justice. Now, lordship will para 13. The court is enunciated. Why? The code of civil procedures, lordship, it is the handmaid's of justice.
Not given a direction, may call for, may call for.
Yes, well.
Yes. Well, why it is necessary?
Well, that is in the suit, my lord.
May call for.
Yes.
And it is in the suit, my lord. Why they have not, my lord, they asked this in the appellate court or the second appeal, my lord? Appellate court, second appeal, my lord, they have asked, and that was considered and everything, my lord.
Now, lordship will para 13, my lord, this is important.
No, and they filed separate petitions under 47 also from other persons, and order 21 rule 96, 97, 100 also. So these petitions are pending. My lord, they wanted to delay the execution proceeding, my lord. So my humble
Petitions under order 2197.
Order 21 rule 97, 100, 106 also.
106 also.
Also filed separately, and section 47 in the case and
where
section
you are asking for records.
so somebody from some other person, some other person, my lord,
Some other person.
maybe, my lord,
By others. Okay.
some other persons, they are virtually relatives, my lord, same virtually, my lord.
Now,
Why?
my lord, Para 13 of the judgment, my lordship may kindly see, para 13, paragraph 13, my lord. Why it is necessary, my lord? The Code of the Civil Procedure observed by the apex court in Songrangship versus Election Tribunal lays down the procedure designed to facilitate the justice and further its and not a penal enactment for the punishment and the penalties, or not a thing designed to trip people up. Too technical construction of the section that leave no room for reasonable elasticity or interpretation should therefore be guarded against, lest the very means of design for the furtherance of justice be used to frustrate it. The apex, so my lord, is court decided that it is the element of justice, and my lord, that has been in paragraph, my lord, lordship will kindly see the learned court below. While in view of my Pira 15, my lord, I am of the view that record of so and so case number under 45, more particular the report submitted circle is necessary for the interest of justice. We said we have no record, nothing, my lord. And my learned friend has said we have not assigned any reason, my lord. It may not be in a, my lord, in hundreds of words, but if it is indicate why, now lordship will kindly say 100 and page 114 again, my petition. Why it is necessary? My lord, lordship may kindly read this petition 114. Lordship has got it, my lord.
Yes.
That as per execution petition filed by decree holder, so and so, it revealed that before filing title suit, my lord, I am not on that, but this is the, my lord, description now said, that it is to be stated that there are 2 numbers of PMI house and 1 government sanctioned toilets, and as well as big pond within the homestead on the petitioner, I schedule 4, with the full knowledge of decree holder. And decree holder every day visit the shop houses and homestead land of the petitioner applicant, and other having every knowledge of existence of the homestead land since the time of predecessor of the petitioner applicant, Binoy Krishna law and others, that without finally determination the share of the decree holder, he filed the title so and so, that the applicant applied for second arrest pattam lucky number where the name of the petitioner applicant was recorded. That further, if execution process of court, the applicant the other financial loss of so and so, and the suit was filed in 79 and decree was passed in 87, and by passing of time, the character demography schedule of them already been changed. So without identification demarcation, schedule land cannot be executed. So why you have not stated, my lord? We have not stated in the hundreds of words or thousands of words, but a sufficient indication is there why this record of the PP case is required, my lord.
But they cannot find a record.
My lord, that is the court, my lord. I am helpless for that, my lord. I cannot be put helpless for that, my lord. Therefore, I said, my lord, lordship, I place this judgment, and my lord, I will place, my lord, why, my lord, 2 judgment of the apex court, my lord, where, my lord, it is said, my lord, the para 28, 29, and 31. Supreme Court judgment. Yes, my lord.
So what is the solution without deciding without finally deciding? There's no solution according to you, but you have a solution?
Yes,
that I can stay the execution.
Yes, yes, ma'am.
My lord, these petitions are filed by my lord Binoy Bhushan Roy's legal aids. My lord, so it is apparent, my lord, they wanted to relate the decree so that the decree cannot be executed at all, my lord.
Lordship, my case is very simple.
Let them file their documents, my lord, before the court, and this is not a trial proceeding, my lord, this is execution proceeding, my lord. Execution proceeding, my lord. No, why it should be stayed?
I'll decide it finally. Then.
Yes, madam. Yes.
I'll decide it finally.
Yes. What my principles are, let them go. Both the parties go identify that if this land that will be over.
That will work then.
Yes.
You are insisting on the record which cannot be found.
Yes.
My lord,
that order I can pass.
That is the duty of the court, my lord.
Yes. My lord.
That is the duty of the court to call for the record, my lord.
But that record could not be traced out for so many years.
My lord, there, I do not know, my lord, but record should be there, my lord. If in absence of the record, no party should be, I should not be put to suffer, my lord.
My lord, with the help of land records staff, my lord, it can be identified. No.
Yeah.
So let it be identified and executed.
Yes.
Yes, yes.
Until then, my lord, no proceeding.
No.
No, my lord. Before I
Okay, I
can
don't
not
think
the
so.
proceeding.
They will identify.
Execution can be executed.
While executing my lord, they will take the help of the.
My lord, see, if the land is not identified, as my land is not been say, my house cannot be bulldozed tomorrow. Bulldozed tomorrow, my. That is why my lord say. Yes. I say to mine. And my lord, I can place of the.
I crores of rupees, I don't know, or one house is PMAY house, I
I-
need not a
this
valuation
land-
of PMAY.
My lord, I have also shown, my lord, that's in the same patta. My lord, my land is also situated. My land is also situated, and the decree also said, my lord, the petitioner
No,
land.
but you see, how can you say your land? It's
My lord-
already decreed in favor of.
Yes.
the-
No, I said about my land. I'm not saying about his land. That I made clear, my lord, to your lordship.
Even-
And that is the identification required. Section 47 also required that the
Even-
identification falls within the ambit of section 47 CPC, my lord. And for that purpose, all this, it is. calling
Section
of the
47
record.
petition,
Yes.
last time I filed there, my lord. They
Yes.
have also filed section 47 petition.
Then how,
Yes. Your lordships can decide. My lord.
so one suggestion is from your side that I can pass an order for your part of the land to be identified.
Yes. Yes,
From-
yes.
From the office,
Yes.
Hmm?
They let them official. Identify.
from the
yeah.
the official.
My lord, the land was, my lord, earlier.
Writ also has been issued.
Yes,
Writ has been
It
issued.
to be issued, my lord, because
So as soon as the writ will be issued, the land will be demarcated.
land will be demarcated. My lord, earlier collector demarcated the land. They found that their house is in our land, but the rent has not been fixed.
Why my land is
So-
outside?
My lord. So it can be identified, my lord. It can be identified.
So there is one option here.
Yes.
If I decided,
Yes.
finally, that's what I'm asking.
My lord.
House or shop in your
My
land?
lord?
House or shop in your land? According to you?
No,
Yeah,
this is
one-
this is
one
my land,
shop.
my lord. This is my land. They have illegally encroached the land, my lord. That is why the collector could not give the person on earlier occasion. That is why we filed the second suit. In the second suit, my land is decreed. And that is why, my lord, against which, my lord, they preferred a second appeal. And second appeal also upheld that the decree, my lord. Now they are saying that no, their house may be there, my lord. They might illegally constructed the house in my position.
My lord, this
In
is
my
not
land.
a matter of pleading. my lord.
Because in the trial court,
let the file an affidavit
trial
then,
court
my lord.
judgment is very
Involve-
clear, my lord, that while executing the, while giving the position, my lord, since houses were there, the, my lord, first position was not given by the collector, and they wrongly did not fix the rent also, as per land regulation.
Because
So,
one
my lord,
contentious issues is arising. That is why this
anyway, my lord.
court has made an observation in the second appeal, para 20, what I had my lord, to my lord.
They
All in contentious
what they
issues.
cannot get it in the
If
second appeal and first
arises-
appeal, my lord, now they cannot
Oh.
get in the execution court.
We are not saying that.
No,
Yes.
Only one
contentious issues.
side is
If
there.
any arises.
My lord.
There's a contentious issue.
Yes.
Any issue
That is
will be
important.
decided
So
by the
that is
executing
arised out
court.
of that
So
contentious.
I'll direct the executing court.
Yeah.
If I decide finally,
My-
Ah.
or
yes,
maybe I may not direct also, I may dispose of in any manner I like.
my lord.
If
my
I
lord.
decide finally, or I may come back to you again
My lord.
after 2-3 days, after
My
2-3 days.
My lord,
Let me find out.
Yes. My lord, then execution may not be, because they have been given an undertaking to this honorable
That's
court.
why I'm saying I'll come
Yeah.
back to you
Yes,
after
it should be
2-3 days.
continued, my lord.
Yes.
Yes.
Because you are asking for stay against the.
Yeah. Yes, lordship.
So, and this is a matter, so 40
Lordship,
years old
lordship.
matter, 40-year-old matter.
I am obliged. lord.
40?
No, 50, my lord, 54 years. 54 years, 71. my
Problem
lord.
is it, my land,
54 years.
land belongs to me, land belongs to, it,
So
my
it-
lord, originate from the entire chunk of land, my lord, that from the one, the minimum.
Maybe.
All the land devolve on us, devolve from them, that's the whole problem, my lord.
So I'm not granting stay because this is an old
Yes.
matter.
Yes.
Only, my lord,
I'll come back, as I'm not granting stay, I'll come back to you after 2-3 days.
Yes. My lord.
If any confusion.
My lord.
My lord.
Because now I cannot find any way out.
Because my lord, the matter has been fixed on 99 in the before the execution court, my lord. So
No,
they
I
may
will-
not
I will-
insist.
I will
Ah.
come back before 99.
Loss.
99.
But my lord, they should not insist for execution of the undertaking has already been given, and that is recorded by this honorable court also, my lord.
Sorry?
undertaking has been given not to put the decree into execution. That undertaking, that is recorded by this honorable court also.
So that is another aspect, my lord, that till today, my lord.
No, that might
Till
continue.
till today,
That
not,
undertaking
not,
may continue.
not.
Where?
Yes, my
Till
lord.
today, my lord, I have given the.
Lordship will find.
To continue.
Please
My lord?
continue, lordship. Yes, please.
Continue. I'll come back on 19. I'm saying you, I'll come back.
Lordship,
on
lordship,
19.
lordship.
With the order or
Right, ma'am.
maybe
Yeah,
I'll
hello,
ask for some
my lord.
clarification.
I'm obliged, lord.
What? Well, it appears, my lord, hearing item 17 may not reach, my lord. Hearing item 17,
Huh.
it may come after vacation, my lord.
No, I think you won't conclude.
My lord. So it may come after vacation, my lord. So,
I think 17 to litigation. I'll list this matter after puja petition. Right. It is the Mr. BJ Ghosh for the petitioner and the counsel Mr. G.N. Sanedana for the respondent. Do total effect to the No, you cannot. কিহত আছে মোশন লিস্ট কৰি দিব পাৰি লিস্ট অন 16 মোশনতে লিস্ট কৰি দিব এই বেলেগকে দি দিলে কিন্তু মোৰ চেম্বাৰ দি দিব পঠিয়াই নিদিব Item 7 or orders.
Well, I am appealing for the appellant here. Lordship has issued notice in the matter and the appeal was already admitted. But in the IA, there is an order. Kindly take up IA number 443 of 24.
For stay?
Stay has been granted, madam.
Stay granted?
Stay granted, madam. On last occasion, 24/1/25, there is a order, the steps we have taken on respondent number 1, service is not complete. Similar order is in the appeal also, but there, the direction was given to me to take steps. I somehow, I missed it. But kindly give me 2 days time, I'll take the steps. Otherwise, for 2 to 5, my learned friend is here. LCR has come,
Other issue is very simple, my lord, only regarding 8 lashes of land, my lord. And rest of the land has been already, my lord, right title interest already, my lord, declared, my lord. Then.
This is in your own capacity, no?
Yes,
not for government?
No, not for government. It's a private matter.
A private. No,
Counsel Mr. D. Nath is present for the applicant. Learned Counsel Mr. H. Das, no?
H. Das.
Is present for respondent number 2 and 5.
2 to 5, my
2
lord.
to 5.
Steps to be taken to issue notice to respondent number 1 within 2 days.
I'll take it.
Only one, no?
Only
number
one.
1.
Oh, we signed it, but no report is come.
Dusty maybe.
Within 2
Dusty.
days. Dusty?
Dusty.
Any means.
Dusty.
By both, my lord.
Both.
Registered. I'll suggest them. Registered as well as
through routed through Dusty service as well as by
registered.
As well as by registry post with acknowledgement due returnable within 4 weeks.
Madam, lord.
Please accordingly.
Lord. The interim order, my lord, that
You have an interim order in
yes, my lord. Till the returnable that court, honorable court has said, my lord.
which
That will continue, my lord. Interim
that
order.
same case. Oh yes, interim order shall remain in force.
Lordship.
Already paid. Yeah.
So it was till the returnable date.
In RSA?
In the IA, my lord.
IA.
IA.
কোনটো IA আছিলে? এইটো নহয় নেকি? আৰু এটা IA আছে নেকি?
No, in the that is the IA, my lord. 443 of 24.
লিখি থৈ দিয়া। Interim order shall remain in force till the next date of listing.
Lordship.
Check cross one.
May your lordship.
Yes.
My lord, I'm waiting for my lord for item number
Everybody.
for this item. Yes, my lord. Lord, I have the 2 submission in this matter, my lord. My lord, this matter admitted on 31st July 2024, my lord, and absolute and order obtained by that against the concurrent findings, my lord. They preferred the second appeal and they obtained the absolute order, my lord, stay order, my lord. Then, my lord, they have taken steps in the 2024 August, my lord. Till date, my client has not received any notice yet, my lord. But when my client has inquired about them regarding pen matter, then they have found in this second appeal, they have obtained stay order on 31st July 2024. Then, my lord, we voluntarily from our side, we file a kalatama, my lord. We mention it today for listing, my lord. My humble submission in this case, my lord. This honorable court recorded 31st July 2004, Lord Court record, my lord. This is the court of, my lord, civil just senior division Kabruk, my lord. 1.5 year this, my lord, almost past, my lord. Till date, the records from the civil court, civil the senior Kabruk has not been received by the registry here, my lord. And, my lord, while submission in this matter, my lord, let the counsel for the appellant to serve memorandum of appeal today itself, my lord. Till date, we have not been served a copy to us, my lord. From our side, we have filed a kalatama. We have mentioned it today. Why they have waited for the last 1.5 year? Why they have not taken any steps since final stay order they obtained, but sitting silent over the matter, my lord. Neither no step has been taken regarding calling of the records. Not even they could have served other process. No, my submission. Let me ask my lord to furnish us a copy today.
Kindly peruse the office note, my lord. 7/8/2020.
And, my lord, my submission is, my lord,
taken steps, my lord.
taken steps, but it 1.5 year back, my lord. And now it is, my lord, 2025. I'm on September 2011 today, my lord. My humble submission, the memorandum appeal may be served to us, and, my lord, registry may be directed to, my lord, intimate to call for the records immediately, my lord.
Counsel, Mr.
DJ
Medi is present here on behalf of?
S. Sharma, S.C. Sharma. On behalf of Senior Counsel S.C. Sharma.
On behalf of Learned Counsel, Mr. H.K. Sharma.
A.C. Sharma.
S.C.
His name is also not in the list.
My senior, my lord.
A.C. Sharma.
Yes, ma'am.
His name is not in the
My lord, my learned senior was appeared on last month admitted this, yes, S.C. Sharma.
My senior.
Yes, my lord, senior advocate.
Senior Counsel, Mr. H.
A.C. Sharma.
A.C. Sharma. Host of Learned Counsel, Mr. P.K. Deka is present for the respondent.
Sole respondent, my lord.
For the sole respondent, host of appellant to furnish copies of the appeal memo along with the relevant documents to
Yes, my
the
lord.
respondent. Call for the original records of title suit numbers.
But appellate court as well as all trial courts records, my lord.
Title appeal number 109 of 2012 as well as title suit
1027.
original record of trial court.
My lord, in 31st July 2024, it is reflected. That order may be directed. 31st July 2024 in IM, my lord.
Title suit number, what is the title suit number? It will serve the
Sir,
purpose.
I order to
Give me
the
the title suit number?
102 7.
My lord, my lord, I'm sorry.
102 of
My
2007.
lord, this is, can you, my lord?
List after 4 weeks,
It is immediately after vacation, my lord.
list immediately after.
Vacation, my lord. And memorandum copy, my lord, today itself, my lord.
It will copy, interim to copy. No, no. Yes.
Yes, ma'am.
May I please go?
Hmm.
The service is complete upon the respondent. Appeal is admitted. Let it be fixed for hearing. Date may be fixed.
Service, one respondent, how many respondents?
2 respondents operate.
Notice has been served for respondent number 1 and 2 through usual process, okay. Learned Counsel, Mr.
D. Mazumdar, Lordship.
D. Muzumdar is present for day. Do we have the trial court records?
Perhaps it's not necessary, Lordship.
What?
It's against an appeal against an rejection of an injunction order.
Okay.
Some fresh input is there, Lordship. FSL report is there. We have annexed it.
They may ask for records.
Lordship may call for the records. The respondents have not appeared, Lordship.
This will
The
get
last
some
location-
procedure actually. Otherwise, these respondents will come, they will ask for records, then it will come back to orders again, it will go back for hearing.
But your Lordship may kindly peruse the order dated 22/8/25.
Office note indicates that notices have been served to respondent number 1 and 2. Call for the scan copies. Scan copies of the trial court record. Will list this matter after puja vacation?
After vacation, Lordship.
List this
Date may be
matter.
fixed also. Possible.
Date. List, huh? List this matter immediately after puja vacation. You may mention and you may upgrade
We'll
it.
make a mention, Lordship. Much obliged.
My lordship, on the last date of hearing, notice was issued and the service is complete. But my lordship, stay was not granted. I would like to press for stay of the proceedings in Udalguri Court. The respondent husband has filed a divorce petition in Udalguri Court, and the petitioner wife resides in Borpeta. And from last 3 years, they are separated.
Have you prayed?
Yes, my lordship.
Have you prayed for stay in this petition?
Yes, yes, my lordship. Page number 12. Last pair. The matter in Udalguri Court is coming up on Tuesday, that is 16th.
It's fixed at which stage?
The
Pending at which stage?
divorce petition matter is coming up on 16th, this coming Tuesday.
16. At which stage? Pending at which stage?
The written, written statement is to be filed, but my lord
is not required now.
My lordship,
We
actually,
can hear it. We can
two
hear-
cases are already being pending
Written
at.
statement, it's at the early stage. We can.
My lordship, one prayer, my lordship, actually two cases
Hmm.
are already pending at Borpeta Court, which was filed by the petitioner. One for the domestic violence.
No, no, we are immediately concerned with this case.
Yes,
this case.
My lordship, actually, I'm praying for stay because
You're praying for transfer of this
from Udalguri to Borpeta.
title suit?
Yes, the divorce petition.
Divorce petition from Udalguri
Udalguri to Borpeta is two.
So have you issued notice?
Yes, yes, my lordship. Notice is being.
So now it is at the stage of written statement, stay is not required.
My lordship, one more, actually, in the domestic violence case, which is pending at Borpeta, the court
we
is,
will take up the matter, let the other side come. We'll take up the matter, even if they don't come also, we can take up the matter. Because you are asking transfer of only one case.
only the divorce petition from Udalguri to Borpeta, because two proceedings are already going on in Borpeta
Yes,
court.
yes.
And both the parties are taking.
We can consider it. Let the notice be served.
Notice is already served, Yes, yes, my lordship. Notice is already served.
Today he is not present.
Today he is not present. That's why my lordship, I'm asking for.
That's why what I'm asking. That's what I was asking. No. Notice has not been served. Neither AD card nor answer notices have been returned for the sole respondent with regard to notice issued by way of registered post with AD.
Okay, in the record, it is not reflected, my lordship.
This
Actually, I
is in
had
the office note.
Okay, I'll look into it, my lordship, because on my part, I had already served it on the last date only.
9/9/2025, office note.
Actually, last order was on 1st September. On the that day only, I had made the service.
It's registered post with AD. If it registered post with AD after a month also, we can deem to be served. We can it can be deemed to be served after 1 month. So we can wait for 1 month, or else we can wait immediately after the puja vacation.
Okay, date will be given, my lordship,
Yeah.
after puja vacation.
Not date. You mentioned and get it upgraded.
Okay, actually, my lordship, in the
DD.
my lordship, just one last submission. Actually, I am pressing for stay because in the Borpeta court, the case is going for mediation, my lordship. That's why. Not 16 October. Can it be a week after Diwali? After, yeah.
Notices issued to respondent is not returned.
Okay.
Service report on respondent respondent is awaited. List on. Then we will decide it.
Okay,
If notice is served, then if the notice turns up, we will get it transferred.
Okay, my lordship, obliged.
May it please, your lordship. In this case, the regular second appeal has been preferred by the plaintiff's lordship. And the appeal was already admitted. Notice was issued, lordship, as per office note dated 8/9/2025, lordship. Unserved notice have been received in respect of respondent numbers 1 to 4 and the same has been tagged shown as flag X, Lordship. No such person in the address. Hence returned to sender. Lordship, their written statement, your Lordship will find page 25. This is the address, same address I have written in my memo of appeal also, Lordship.
We send it to Lalima Code.
Lordship, in this case, what happened after admitting the appeal, after issuing the notice, they are willfully, Lordship, refraining themselves from receiving notices because they have already, Lordship, filed an execution proceeding, Lordship. And in IA also, Lordship, notice was issued, and in that case also, same office note, Lordship. So my humble prayer before your Lordship, in my IA, when notice was issued, that may kindly be stayed till the next day. As per office, as regards the notice issued by usual process, no service report has been received.
In your
So
IA.
we may
In your
wait.
IA.
Yes, Lordship. In IA and regular second appeal, in both the cases, Lordship. So we
Second
may.
appeal, it has been sent because address is not sufficient.
As
Not
per-
found in the address.
Registered post, Lordship. But as regards the notice issued by usual process on 8/8/2025, no service reports have been received till date. So for usual process, we can wait for some time, Lordship.
Yes.
My humble prayer, Lordship, they have already initiated execution proceeding, and my suit was decreed by the learned trial court, which was reversed by the first appellate court, directing them to pay the amount to the plaintiffs, Lordship. Suit was for specific performance of contract. Trial court decreed our suit, and that was reversed by the first appellate court. An appeal already admitted, Lordship. So stay of the further proceeding, operation of the impugned judgment is required, Lordship, so that I can submit the certified copy before the executing court. Not to proceed further, Lordship, as the appeal already been admitted, Lordship. And the address which I have.
When did they initiate the execution proceeding? When was the
No,
judgment?
later on they have received, that is title execution number 3/2025, Lordship. It was issued in the month of July 2025.
How far it will go? It won't go very far.
Lordship, they will submit the entire amount and there may be an writ will be issued to accept that amount, Lordship, as because the first appellate court held that they were directed to pay the amount to the plaintiffs, Lordship. Page 85 memo of appeal, your Lordship will find.
No, not now. If any conduct, if any
Lordship will file their written statement, they have written the address. The same address I have written in
I'll check it next date. Any shady conduct by them, then I'll pass an order.
Lordship. Then
but not
next
now.
week, your Lordship. If
Not
your
next
Lordship,
week, no. After vacation.
before vacation, Lordship.
No.
It will
Before,
proceed.
Execution proceeding.
We have already submitted the certified copy of the notice order by which the notice was issued. But executing
very far.
But executing court is saying
Pooja,
that
you see, we'll start vacation will end before just a few days more than a month. We know how far execution proceeding goes. We
Then
won't
you're-
go very far.
immediately after reopening.
Yes,
Lordship,
immediately.
Then on 13 or 14, Lordship, any date.
Yes.
October.
I can pass an order. Then I'll pass an order.
Lordship.
If they are avoiding
Lordship,
conduct.
Lordship may record that, the Lordship may record that in my stay petition, Lordship.
We'll consider. I am giving you my word. We don't.
Because Lordship, I have given the address which is written by in their affidavit, Lordship.
Avoid. This is
Lordship.
what everybody
They are
does.
avoiding, and in other words, they are
This is
file
what
already
everybody
exists.
does.
So
Who
as
is
per
the
office note,
who is the
Lordship,
JD?
await-
He will always do what he will be up to his tricks.
Lordship.
We know how the JDs behave.
Then your Lordship await service report for that.
We'll
usual-
await for
usual
service.
process, Lordship.
Service report on respondents are awaited. It will very liquid by IA.
In appeal and IA, both the cases
Appeal
notice
appeals.
was issued.
IA repeated. Service report on respondents are awaited. List the matter immediately after Puja vacation. Or you
Yeah.
want a date?
13, 14 in
Date
date,
of the delay.
14 October, Lordship.
14 dila na?
Obliged, Lordship. 12, Lordship, we have filed one IA for early hearing. And as per office note dated, Lordship, that is 5/9/2025. Process servers report, Lordship, respondent number 1 not found. Others, respondent number 2.1, 2.2, 2.3 refused to accept. And others already served, Lordship. The service complete except R1.
Not found? Why is not found?
Lordship, maybe the address is different, so we have written from the written statement.
We can fix it for early hearing, but notice has to be served, no?
Lordship, in the appeal also, we have served notice 2-3 times, they have refused, Lordship. Now, in the IA also, they have some of the respondents
No, it's
refused.
okay. If they refuse to accept, then.
Lordship, so
We will
2.1,
deem it, we'll pass an order for deemed service. But respondent number 1 has to be here.
yes, Lordship.
Then only we can take up for early hearing.
Lordship, then service complete in respect to respondent number 2.1 to 7 and await service report for respondent number 1.
Applicant is represented by learned counsel Ms. R. Chaudhary. Respondent service report on respondent number 1 is awaited. Respondent number 2.1, 2.2 and 2.3 has refused to accept notice as per the office note dated 5/9/2025. Full stop thereby. Notice is deemed to be served on respondent number 2.1, 2.2 and 2.3. Notices have been served to all the other respondents. List the matter immediately after puja vacation.
Lordship. Obliged.
Yeah, please, again, this matter has came out for orders. I hope the land code remembers it. On the last occasion, actually.
Mati Shubli ko pasun. Mati Shubli ko pasun. Shubli ko pa. Kilian ke bye koi yes. Pass an order again. I'll pass an order. I'll fix it for bail hearing after talking to them.
Okay.
And calling them. I'll fix it. When do you want?
Maybe tomorrow is closed, as I know. So Monday will do.
Monday, yes, we'll fix it for Monday. Not Monday. The list is already ready. Monday's list is already ready.
As the code, please.
On 17.
It is fixed for this bail hearing.
Yes, bail hearing.
Lordship, earlier date it was also bail hearing, but it again and again come under order, Lordship, because I have to come from Agartala, so I have to suffer, Lordship. So kindly.
On 16 then. You stay back till 16?
16. Okay. Yes, it can be done.
He's also here.
I'm here. I'm a local over here. 16 will do.
List this matter positive for bail hearing.
16 on bail hearing.
So baki khini mo pass koi din ha. Dot likhi din. On 16 likhi diya. Baki khini dot likhi thodi diya. Soi na koi diya.
Obliged.
May I please, Your Lordship? Your Lordship, the Union of India has appeared, Your Lordship. Your Lordship, this matter pertains to, Your Lordship, condonation of delay, Your Lordship, interlocutory application. Condonation of delay for 10 days, Your Lordship, in filing the miscellaneous first appeal, Your Lordship.
I think 13 days.
Your Lordship, I have been instructed that it has been a delay of 10 days, Your Lordship. Defective.
Anyways.
10 days.
10 days?
Yes, Your Lordship. The matter was kept on defect, Your Lordship. I have placed it 13 days, but it was defected and
You
it's
have any
rectified.
objection?
No.
Learned counsel, Mr.
DS Decca, Your Lordship.
DS Deka is present for the applicant and learned counsel, learned standing counsel.
Central Government Council.
Learned Central Government Council for Railways.
Yes, for sole respondent. For the sole respondent, that way.
For the Railways, Mr.
CKS Barua.
CKS Borwa is present. Full stop. This application is filed for continuation of delay of 10 days in preparing the connected appeal. It is submitted that, what is your ground?
Your Lordship, at page number 10, Your Lordship, para number 12, Your Lordship, the petitioner was ill, Your Lordship, and therefore she could not communicate the certified copy of the order. At page number
The
14.
petitioner was not well.
At
she
para
was
14,
unable
Your
to
Lordship.
communicate with her lawyer, with the engaged counsel.
Yes, Your Lordship.
To communicate with her engaged counsel, full stop, to communicate to her engaged counsel about the what is the case number?
Yes, Your Lordship.
About the impugned judgment and order dated
28/2/2025.
28/2/2025 in connection with
Original application number, Your Lordship, 61/2024.
लिखिएगा ना विषय मिली आपको लिख लिया The learned counsel for the respondent has no objection. Certain grounds have been shown. No matter is discernible. They have a delay from registered to register the connected appeal.
Much obliged, Your Lordship.
Your Lordship, in this present appeal, certain new facts are to be incorporated. Your Lordship, at this stage, I am asking leave of this court to file an additional affidavit along with an interlocutory application such that the new facts should be incorporated into the memo of appeal. And Your Lordship, another thing is that as per at the page number 10 of the judgment and order, the mother was represented in the appeal in the original tribunal stage. Now the claimant was able to sign back then in 2020. Now he is not able to sign and move in vegetative state. He is not able to move, Your Lordship. So the leave may be granted. The mother may represent the claimant.
No. There has to be an application.
Yes.
Interlocutory application.
Seeking leave of this honorable court.
Learned counsel, Mr.
A. N. Iqbal, on behalf of S. Rahman.
A. N. Iqbal is present on behalf of
S. Rahman.
S. Rahman for the applicant, for the appellant, and he has submitted for time to file an additional affidavit along with an interlocutory application. Learned counsel, Miss.
Respondent number 3, M. Chaudhary.
M. Chaudhary is present for respondent number 3.
Lordship.
List this matter after vacation.
Yes.
Must oblige.
Oblige.
Item 38.
Lordship, in this case, the IA 1610 of 2024 is, which is prayer for stay of the operation of the impugned judgment and decree. Your Lordship was pleased to fix the matter today and to file an objection, if any, by the opposite side. But was probably not filed. So if Your Lordship takes up the matter for stay, because it's a matter of concurrent finding. May I start?
Question is that, Lordship, there is no case already. Our land is allotted land, ceiling surplus land. How can they grab this money? It is our question, Lordship. They have not seen any document, not a single hand note also, Lordship. That's why court has given the very good finding, Lordship. Kindly see what is the fact, Lordship.
Facts are not entertained at the second level stage. It's the mandate of law. If any pure question of law and perversity is there,
Lordship, kindly necessary
Section
party must be
100
impleted.
applicable
Still
only
necessary
on
party
that
is not
ground.
impleted. Necessary party is still not impleted. How can they seek
It is
stay?
the suit filed by the plaintiff side. We were added as defendant.
No.
And if Your Lordship permits me to submit today, my hearing part, Your Lordship.
I don't think so. We have
Or
sufficient time
Your
to-
Lordship may fix it on Tuesday, because on 17th, our day is for execution. On the last day, I have also submitted.
Execution is going on to
And
the
that
12th,
is
Lordship.
for report and
Still it is
payment,
going.
Your Lordship.
But they,
Because stay
even
application
if
is not
they
considered
arrested,
till date.
but not given any single coin, Lordship.
There is an application pending 3192.
Not on
2020.
Tuesday.
Your Lordship,
Not on Tuesday. Tuesday is a hearing day. Either Monday or Wednesday.
Monday, your lordship, Monday, lordship, Monday, because 17th is. the deadline.
Another case.
Monday is not possible, Wednesday maybe.
After
Then on 17th, your
after
lordship.
vacation, idly.
No, after that, then on 17th.
No.
execution will be
After
done, your
vacation,
lordship.
lordship, kindly see.
We have filed an additional affidavit also citing all these things. Your lordship kindly
It
take
is continue
take
for
into
2012.
account.
How can you can?
And this learned counsel every time does not allow me to submit. Every time I am barred from making my submissions, your lordship.
So kindly see page 19 in
And
his
if
petition.
it's admitted.
Plaintiff and
then
defendant
accused
number
and-
1 is appointed.
Your lordship, why I am praying for the stay during the pendency?
This whatever is required money, lordship already.
Maybe it is a
divided.
concurrent finding, but Supreme Court finding is
Kindly-
there.
kindly-
Concurrent finding cases of.
Okay, give me 5 minutes, I'll come back and hear you out. But what about the others who are sitting?
State is also there.
List will be over by then.
No, not here. lordship.
Huh? No, others who are sitting and waiting.
Today all are absent, lordship.
No, they're at the back.
Lordship is not likely to take any hearing matters today.
No, not possible. Not possible at all. I think this matter will take some time.
Just clarify one things. Plaintiff, there is 1 to 4.
It will be left over. Other matters will be left over. I'll come back after 5 minutes. This matter will take some time, I think. I'm sure this matter will take some time.
Next maybe after.
No,
After this week, lordship.
If possible.
Next
No,
week.
no, next week, it's not possible actually. Next week it's not possible and the last week will be for motion only. And
After vacation, lordship, what matter?
if I can hear, I
in
can
that
hear
case-
today, otherwise I'll hear after vacation.
In that case, I may be protected until
No.
the next day. Then your lordship may hear me today.
I'll come back after
Yes,
5
yes.
minutes. And what about the others who are sitting?
My lord, item 18, 19, my lord. My lord, kindly, my lord, next week, my lord.
No,
private-
next week,
Because lordship
that is why I'm hearing them because next week I don't have time.
My lord, because my lord already since 2 years back, lordship, this honorable court already allowed our early hearing petition, lordship. And since then, lordship, it is not hard. So kindly, my lord, on 17th, lordship.
I'm sorry, you see,
This way or that way.
Yes,
this,
lordship.
this matter will take me some time. So, and next week, as I do not have time. I'm
On
going to
17th,
get
we
this
will,
matter.
lordship, try our luck, lordship.
No. It's not possible because it
My
will
lord,
be left over and then again I'll have to debate with you.
My lord, on 17th, lordship, if your lordship allowed, lordship, because lordship, last week.
17th already, you see, as I was trying to accommodate 17 already I fixed a matter at 2 PM which will take quite some time.
Then, my lord, immediately after vacation, lordship.
Yes, maybe immediately after.
On
vacation.
14th.
Immediately after vacation fix kore dibo pari.
13 is Tuesday.
13 or kiman?
18, 19.
18, 19.
My lord.
Is this matter immediately after
Okay.
vacation?
My lord, item number 33, it is in the hearing list. Let it come after vacation on a fixed date.
On a fixed
I
date.
have some urgency. Let it- 33 on a fixed date after vacation.
If you have urgency, then we cannot fix a date because if we fix a date, it will go beyond November.
Lordship, I would
I
just,
do. Item 33.
If we fix a date, it will go beyond November. If you want immediately after vacation, we'll fix immediately after vacation.
Yes, immediately after vacation.
Yes. But if you give a date, particular date, it will go beyond November because we already have again many matters fixed.
After vacation. Of like,
I am appearing for the respondent. I am not finding my friend appearing for the appellant. I think, my lord.
He may not turn up.
My lord.
Okay.
So.
Item number?
Item number 40, my lord.
Learned Counsel, Mr. BK Sen, no?
BK Sen.
BK Sen is present for the respondent. List this matter immediately after puja vacation. Because we'll have 2-3 benches.
My lord.
2-3 civil bench one. So it may come up before any bench. If you
Yes,
fix
yes,
it, that will come before me and that will come after November.
May I please, Lordship? Lordship, item number 38. I'm appearing for the state of Assam, Lordships, 6, 7, and 8 respondent. It is not over. Okay, sorry.
Please, your lordship. May I please, your lordship? Lordship, This matter has been fixed for the hearing, so can we maybe fix on the after vacation?
Yes, immediately. after
Item number
vacation.
20.
Immediately after vacation.
Much obliged.
I'll come back after 5 minutes.
Now the cases of concurrent finding, admitted on 27 6 2024 on a substantial question of law framed on the ground that necessary party, that is National Highway Authority, in the entire proceeding was not made party in suit or appeal. Suit was filed by the respondent plaintiffs. We were the defendants. The suit, the brief fact of the suit that the plaintiffs filed a suit praying for decree for declaration that the suit land pertaining to DAG number 42 by 195, land measuring 1 katha 7 katha 4 chatak, acquired by the National Highway Authority for construction of a bypass road of NH 154 from the possession of the respondent plaintiffs, who has got the right through their predecessor, who was the allotee of that land, one of the allotees of the land, and also the a sum of rupees 2,25,000 has been assessed for as compensation money, and that is to be, they are entitled to this, and also the 91,000 that has been awarded to me along with respondent number 6. He was the one of the defendant number 3, should be returned back to them with the declaration that we do not have any right, title, claim over or possession over the land. Now, in this connection, we have filed our written statement stating that we have denied everything, stating that we were not over the land, possession of the land of the respondents plaintiffs. Actually, it belonged to the predecessor of the father of the respondent plaintiffs, and we had on possession of the some other successors, being the relatives of the predecessors, who were the allotees. Now, in this case, and one we have taken into account a miscase also, where ADC passed an order in our favor. We are eligible to get 91,000 over the ceiling surplus land. The class of land is the ceiling surplus land, based on the fact of possession was proved in the miscase. Now, the trial court framed as many as 6 substantial questions of law. If your lordship kindly peruse the copy of the record of second appeal. In page 14, issue number 2 was, one is that whether there is any cause of action filing of the suit, whether the suit is maintainable in its present. Page 14 of my appeal memo, your lordship. Page 14 of appeal memo. Okay. Now, issue number 2, whether the suit is maintainable, leaving all other things, we have pressed the second appeal. Issue number 2, our part, we have stated that this issue has not been decided. There is a perversity. Whether the suit is maintainable in its present form and manner. Now, regarding issue number 2, at page number 15, para 5, the trial court finding. As regard the maintainability, issue number 2, the plaintiff instituted suit for declaration of the plaintiffs and defendant number 1 are the legal heirs of so-and-so and entitled to get compensation money of bypass road of NH 154 for land.
So you are
so-and-so.
defendant number 1.
I am the defendant number 2.
Plaintiff and defendant number 1 are okay. Okay.
Now, so-and-so, 4th attack of land from DAG number so-and-so. As per the provisions of section 9 CPC, widely construed the jurisdiction of civil court, civil nature of cases, jurisdiction for civil nature of cases, unless it is barred by some
specific status, and thus the plaintiff suit is found maintainable in the present form and manner in absence of any bar created by a specific law. Accordingly, the issue of maintainability is answered in affirmative, which is the main perversity that has been raised by the second appeal at the second appeal stage. Now, other issues, be that as it may, it will be at a part of hearing. Finding of the trial court was that we are not eligible to get, and we should return the money because we did not prove our possession and everything and anything. Order is at page 19, and we have been given an order that we should return the money of 91,000 within a period of 2 months. Defendant number 2 thereafter filed an appeal, and in the second appeal also, if your lordship kindly peruse my of the appeal memo. Yes. Page number 32, your lordship.
Page 32, yes.
Yes. Actually, it comes from page number 31, point number 7. Here, the first appellate court discussed the issues. Thereafter, a point for determination has been stated as page number 33. Thereafter, your lordship. Page number 37, that is the operative part. The first appellate court discussed about the provisions of National Highway Act 1956, stating that if any issue raised regarding apportionment of compensation money, the person concerned should, as per the NH Act section 3H, first of all, they should file an application before the representative or the authority of National Highway Commission. If that could not be decided as per the Act, then the authority will refer the matter to the civil court for decision. Now, in this connection, although the first appellate court discussed entirely, but the first appellate court's finding also purposed, because the first appellate court finding was that as the state's action, the state of Assam or the state authorities' action has not been challenged by the plaintiff side, so civil courts has the jurisdiction exceeding the jurisdiction as provided under section 9 of the CPC. If your lordship kindly peruse section 9 of the CPC.
Civil court jurisdiction?
Yes, your lord. Page 21 of the CPC book. May I read your lordship?
Yes.
Courts to try all civil suits unless barred. Court shall, subject to the provisions hereinafter contained, have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. A suit has also properties and so. Now, in this case, jurisdiction of civil court is maintainable until it is specifically barred or some other law is there. In that connection, we have, while filing the RSA, we have stated in our appeal memo that Union of India, as per section 79 of the CPC, when a state action has been challenged, then Union of India or state of Assam should be a party, prima facie. Now, secondly, regarding the maintainability of the suit, and thirdly, we have stated, without approaching the National Highway Authority, they directly approach the civil court where there is a provision in section 3H4 regarding apportionment of the money. If there is any complaint regarding apportionment of money, the aggrieved party can approach the National Highway Authority. Then the National Highway Authority, if cannot determine, it will be referred to the civil court. Now, out of that, this honorable court was pleased to take into account that national take into
NHAI case kon ase niki? Record kitab kon NHAI.
I have.
I think we have. Yes. Which section?
Section 3H, Your Lordship. 3H4. Page 5 of the Act. Your Lordship.
Yes. Got it.
Section 3H4. If any dispute arises as to apportionment of the amount or any part thereof, or to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction within limits whose jurisdiction land situated. The amount determined if there is any dispute regarding the apportionment, the party should prima facie approach the authority regarding apportionment, dispute regarding apportionment. If that cannot be decided, then the authority will refer the matter to the competent civil court of its jurisdiction. Now, based on this Honorable Court framed this issue on 27/6/2024. Now, my humble submission is that IS Civil 1610, when we have filed, we have prayed for stay of the operation of the interim judgment and decree. Although both the case in in trial court and first appellate court, we did not win our concurrent finding. As the issue of maintainability on non-joiner of necessary party is an issue that is to be decided first by any court, or it can be raised at any stage. So execution case is pending before the trial court. Notice was issued, parties has appeared. On 2 occasions, learned the opposite parties prayed for filing of objection. Till today, nothing has been filed. But execution proceeding, we did not get any stay till today. And fixed next date is 17th of this month for report and payment. So my humble submission is that I have 2 judgments of the this honorable court. Regarding this, Your Lordship may kindly peruse Order 41 Rule 5, in which we have filed the application under which provision. In first appellate stage also, although under section 100 for the last as a second appeal stage, at the second appeal stage, this honorable court is only admitted on the ground that there is some part, only the second appeals are admitted if any perversity or issue of law arises. Question of fact does not take, this honorable court is not bound to take at this stage. So as my submission, as there is a point of law is stated to be perverse by this honorable court, and as we have filed an application under Order 41 Rule 5, the Lordship may kindly peruse the CPC Order 41 Rule 5.
Order 41 Rule 5 is. Yes.
Generally, an appeal shall not operate as a stay of proceeding under a decree or order appealed from, except so far as the appellate court may order, nor shall execution of the decree be stayed by reason of only an appeal having been filed from the decree. But the appellate court may, for sufficient cause, order stay of execution of such decree. Then an order of appellate stay of execution of decree is effective from the so-and-so. Now, in this connection, 41 Rule 5, Sub-Rule 3. Sub-Rule 3 may consider no order of stay of execution shall be made under subsection 1 or Sub-Rule 2, Sub-Rule 1 or Sub-Rule 2, unless the court making is satisfied substantial loss may result to the party applying for stay of execution unless the order is made, and then the B is that the application has been made without any reasonable delay. Now, third point is also there, the security has been paid. So prima facie 2 points is that as this honorable court has admitted the appeal, because non-joinder of state of Assam or Union of India, where the entire exercise has been done by the National Highway Authority, and they should have been made party in the suit. That was not done. In appellate stage, the Honorable First Appellate Court, although discussed the same, but exceeding its jurisdiction, did not take into account that the state or as the National Highway Authority is attached, Union of India should have been made a party as per section 79 of the CPC. So these points we have raised, the Honorable Court also admitted the appeal purely on the ground of law, Your Lordship. And if there is an issue of ground of perversity regarding applicability of maintainability law is there, maintainability of the suit is there, I do pray Your Lordship to kindly stay the proceeding until the second appeal is heard, Your Lordship. We are not saying that because if I do pay the money, 91,000, I will be one apportion part I will pay. But if I do pay, the entire RSC will be infructuous. I have two judgments of this Honorable Court, of the Honorable Supreme Court, where it has been stated, two modes are there. First of all, it has been stated that during the pendency of an appeal, any order having serious civil consequences with the appeal must be stayed. I am producing it before Your Lordship. Two judgments I have. Second one is regarding relating to security deposit. In this connection, the opposite parties have filed one IK 3192 last year, 2025, that if 50% of the money is paid, then stay may be granted. We are agreeable to pay some part of the money, and we are paying for a stay. It is their application, Your Lordship. We have not filed it. We are agreeable to pay 25% of my part, Your Lordship. But until the RSC is
judgment, you are referring to Mulchand or Atman?
Yes, Your Lordship. Yes. Yes, Mulchand, Your Lordship.
Paragraph?
The entire judgment speaks about this, Your Lordship. Very short judgment.
All right. I'll discuss this judgment.
And second one is regarding Lordship, Order 41, Rule 5, sorry, Rule 6, Rule 5, Sub-Rule 3C. And 3192 is pending, Your Lordship may take into account, because if we pay 25% of that, we are agreeable to pay that. And because if I do pay entire money, my RSC will go, Your Lordship. So at least if the RSC does not get infructuous, for that purpose only, we want to stay until disposal of the RSC, Your Lordship. That is not it.
May I please, Lordship? Kindly, Lordship, page 10, Lordship. It is the judgment of trial court, Lordship. It is respondent number 1 to 4.
10.
10, Lordship.
In the appeal?
No, it is title suit, Lordship. 1 to 4 is petitioner, the plaintiff, Lordship. And today I am also in respondent. And 1 to 4, yeah. And the respondent number 2, that is Shafiqur Rahman, is appellant, Lordship. And also, Lordship, 4 district collector, 5 LA Hailakandi, LAO, 6 deputy commissioner, 7 the Secretary, Government of Union Ministry Shipping Road Transport and Highway, New Delhi. Highway authority, why not? He said highway is not implemented. They are also party, Lordship. 4, 5, 6, and 8 are highway party, Lordship. First of all. Then Lordship finally see the fact of the case. It does not stay still. I just read also. This is the suit for declaration of the plaintiff and defendant number 1. Defendant number 1 is the brother of plaintiff.
No.
Facts
See,
only
we'll not go
undertaken
to
at this
facts. She has stated as per section 79 that the Union of India has to be implemented as a party. Highway has been implemented.
Implemented.
Union of India is not represented by
Hi-
someone.
Highway is also implemented. Also, it is also
Section
findings
7
is there.
is not when
You can sit. Well, please sit. Mhm. Highway is implemented, Lordship, because
Highway is
page-
implemented.
Oh, Lordship. Page.
But UOI, what about UOI?
No, also it is.
The LA, had it been an LA case, then it was correctly implemented that those parties were correctly implemented. But now National Highway, then I think UOI ought to have been made a party.
National Highway is also already party, Lordship.
National Highway is party, but
Party.
Union of India.
Union of India, Lordship, question is that it is also clearly written in the
Let her deposit 50% and you will state.
yes. I
No,
will agree
here
with that.
there'll be a speedy
without
hearing of the
50%,
appeal.
this one, the RSA is not admitted either. It was not
RSA has
stayed.
been admitted.
Already been admitted, your lord.
No, I don't know if it is admitted or not, but also when I know it is admitted, then 50% this question is not come.
This is their
Question-
application, your lordship.
Even if they got 2 times jail, Lordship, also not to give single coin, then my question is that though they has no any locus, this is also allotted land, and allotted land, Lordship, it is clearly written.
We'll fix this case for early hearing. We'll grant the
Yes,
stay.
your lordship, I am not.
We'll grant the stay and fix
Yes.
this case for early hearing.
Yes, we are agreeable to that.
Otherwise, you see, this appeal will become
After,
infructuous.
after stay, Lordship, the case is already
We
final.
are giving undertaking that we will pay.
How can you say after stay case is final?
We are giving undertaking that we will fight
First,
25%.
first give me 50%, Lordship.
50% will be
After 50%, if he give, then it can stay.
Yes,
give
yes,
me
Lordship,
stay, Lordship. I have no objection.
Yes,
your lordship,
that's what I'm saying.
say.
After 50%, Lordship. But
It
they
is
said
substitute.
the 50% stay is only in same time. No, Lordship. Even if he is arrested but not given. Arrest warrant is also there, Lordship.
Lordship,
It is
may I
from
submit one thing?
2012 it is to
At
continue.
the first appellate stage, as a statutory appeal, we got the stay. Now at the second appeal stage, there is a mistake committed. The honorable court asked me whether is any execution case is pending. What happened? There is some miscommunication happened. The person concerned is about 68 to 69 years of age, having a stroke, had a stroke.
Surpass
Now-
selling land, Lordship is not any locus of this land. How
That
can
is-
he
it is-
grab this building? It is
Yeah,
our question.
Lordship, whether we have locus or
If I
not,
said something, he said, no, fact is not fact. It is fact.
without
Though there is no head, how can it headache is come?
without implementing following the
Just to
provisions of
manage
section
also, it is also
95.
finding clearly, Lordship. If you give me provide time, I can give it also.
See, they're not relating to this appeal has already been admitted.
Appeal
Admitted,
is
Lordship.
also been
So what is the point of resisting?
Give me 50%, Lordship.
Yes, we are
Yes.
agreeable to pay.
And stay after 50% is stay.
We will definitely
Yes.
pay. We are giving undertaking.
Subject to the condition.
Yes, your
Lordship.
lordship.
Just 50% give me. Today is 50%. Stay may not be allowed.
It is there pair in 3192, 2024 most probably. The application is there, your lordship.
50% give me.
Yes,
Then
we
you
will
can,
pay. We are agreeable to that.
It is
Duita
okay.
economic point you get.
then you can 6 days.
We are going to I number which one now?
3192, 2024.
3192 ekelege কৈ দিওঁ আৰু and the other one
1610, 2024.
And they were allowed to implement the,
We are
still
going
not
through the
implemented.
matter by the
886 days is delay, Lordship.
that
Respondent number
submitting your lordship.
1, Lordship.
We have filed an objection.
I filed
so-
objection, Lordship. 886 days also delayed. There and also clear judgment is also there.
This application.
Intentionally, denied cannot be condoned, Lordship.
There is no
Clearly
delay
written.
in the appeal, your lordship.
Clearly
Totally
written.
misleading the court,
Intentionally
your lordship.
delay.
If it would have been, then IA would have been disposed of first. Issue notice would have been issued.
No, lordship.
দুটা ক্লাব কৰি একেলগে লিখি দিয়া।
Notice would have
IA
been
number 1610-2024, IA number 3192-2024. Third, learned counsel Ms. S. Dasgupta for the applicant in connection with IA Civil 1610-2024 and respondent in connection with IA number 3192-2024. Third, Mr. A.H. Alamgir, learned counsel for the respondent in connection with IA number 1610-2024 and applicant in connection with IA number 3192-2024. Full stop. The full stop. The IA number দুইটা লিখি দিবা দে IA and দুইটা case লিখি দিবা. The IA number 1610 of 2024 is filed under Order 41 Rule 5 read with Section 151 of the CPC for stay of the impugned judgment and decree dated 7/5/2024 passed by the learned Additional District Judge Hailakandi entitled Appeal number 3/2016, dismissing the appeal and affirming the judgment and order, judgment and decree dated 2/2016 passed by the learned Civil Judge Hailakandi entitled suit number 14/2012. To stop, the applicant was directed to return back rupees 91,000 to the opposite party respondents within a
Lordship,
period.
may I submit appellant along with respondent number 6, defendant number 2 and 3, both well.
Okay,
Yes,
give me the names.
Lordship, I will.
The applicant Mohammad Sofiqur Rahman.
He has the defendant number 2, your lordship.
Sofiqur Rahman,
Now the question is that who will receive lordship?
Huh?
This defendant number 2 that is
3 is also there.
still included, not included. His
Lordship,
his
that
child
is
is
a
still
different-
not included, lordship.
820 is different, your lordship. He is ever dragging
can this
820 IS7.
Mohammad Sofiqur Rahman, Mazhar Bhuiya, and Mosmot Tayarun Nisa.
And defendant number 3 is Muhammad Ajimuddin. These two people are the judgment debtors, your lordship. Liable to pay 91,000, your lordship.
And Mohammad Ajimuddin.
Ajimuddin is defendant number 3 and respondent number 6, your lordship.
Mohammad Ajimuddin, the applicant, Sofiqur Rahman Mazhar Bhuiya, and respondent number 6, Mohammad Ajimuddin, both are directed to return back rupees 91,000 to the opposite parties stroke respondents within a period of 2 months from the date of the decree. Full stop. The learned counsel, Mr. A.H. Alamgir, no? A.H. Alamgir has raised serious objection stating that the applicant's land, the applicant has no stake over the land as the land was a ceiling surplus land.
Ceiling surplus land, not it. Allotted to the petitioner's father.
It's okay, we'll not go into that detail. Ceiling surplus land, full stop. He has raised serious objection against the prayer for stay of the impugned judgment and order, judgment and decree dated 2/2016 in TS number 14/2012. First off, it is submitted on behalf of the applicant that at this stage, the substantial question of laws are to be taken up for consideration and not facts of the case. First off, the Union of India has not been made a party, and this suit suffers, and this suit suffers as the necessary party has not been. Suit suffers for non-gender of necessary parties. Full stop. the learned counsel for the applicant has submitted that has quoted order 41 rule 5 order 41 rule 5 within bracket heri hobo niki 3C na
3C, yes, your lordship.
rule 5 3 within bracket C of the Code of Civil Procedure, and this is not required. Which reads, eto tumi sai loba ha rule 5 must do, which reads because dot display to the learned counsel for the opposite party, Mr. A. Shalamgar, has strongly resisted the prayer. Full stop. I have considered the fact that the RSA 66/2004 has already been admitted on substantial question of law. Full stop. I have also considered the petition number 3192/2024 filed by the respondent. Full stop. Considering all aspects, this court deems it appropriate to stay the proceedings at least till the next date of listing. Full stop. Thereby, the operation of the impugned judgment and decree of TS number
Title appeal number, your lordship. We have prayed for title appeal.
TA
Affirming the judgment of the title suit.
Okay.
Title appeal 3 of 16.
Title appeal TA number 3 of
2016, your lordship.
2016 is stayed till the next date of listing, subject to the condition that the applicant, what was his name?
Safikur Rahman Majar Bhuiya.
Safikur Rahman Majar Bhuiya deposits.
And
Respondent number 6, Azimuddin, deposits 50% of the decretal amount.
Yes, sir.
Before the
Executing court, your lordship.
before the executing court.
Yeah. Because the fixed on 17th, your lordship.
Within 1 week?
Next date is fixed on 17th, your lordship.
Okay.
No. I am not available system.
No, I will not give a date.
After 17.
Immediately.
Okay, yeah, as your lordship.
Immediately.
Okay.
With immediate effect. In terms of the above observation, both the application stands disposed of. Yes, we'll fix this RSA for hearing then.
Yeah, okay.
As the records are before us, list this matter for RSA, list this matter for
Sorry,
hearing.
party should be included.
Lordship, in this connection, ISCB 820.
We will take up the matter some other day.
The applications are pending, your lordship. What happened in this?
Then
case?
we will fix it for order and not for
Yes,
hearing.
yes, your lordship. Yes,
For orders.
Yes, your lordship. It will come up for
We'll
order.
take up the matter on some other day.
Yes, your lordship.
Today we have disposed of two
Yes.
petition and before getting more confused, it will be better to release it for some other day. Already I'm getting confused.
Highly obliged, your lordship.
Oh,
See, I'm for.
learned government advocate is present for the learned government advocate, Mr. TR Gogoi is present for the state respondent.
9.
No, state respondent. A application ki khonat aru RSA respondent number 7, 8 and 9 on the application of state respondent likhiba.
One thing is also, I think maybe if it is submitted in court, how can the party receive?
Executing court, your lordship. Their advocates are there, your lordship. They are doing their cases on every day.
There is only the clear 1 to 4 is there.
You want to get it submitted in the registry?
Okay, that will be done also. I don't mind. But
Executing court to cut it here. Let it remain blank. You submit wherever you feel like.
it will be better if the local court they receive because persons are residing locally.
Yes.
They-
Local court, but
Executing court is
the respondent of 1 to 4 can receive.
yes, they will receive actually.
It is
They
written.
will come personally and receive.
Receive.
Then the court will
They will
decide.
decide.
Execute before
They will
the
not decide lawsuit. After the high court order loss.
no, they will decide.
This
Who
order
is-
will be communicated, Your
Who will submit and who will receive, they
It
will
will be
decide.
either, yes, Your Lordship.
You, they will take bond and all, everything.
Maybe
they will decide.
bracketed this. Better.
On that day of execution.
1
or
to 4, 1
before
to
The
that,
respondent,
Number one.
the respondents, what are your, the names?
Number Parasuddin and
Who are appearing before the executing court?
Parasuddin, Rafiquddin, Tayarun Nisa,
The
And-
respondents in this court, namely Farasuddin,
Parasuddin,
Rafiquddin,
Tayarun Nisa,
to be silent about
And-
that.
Foyjun Nisa.
And
So-
Fajun Nessa may receive the amount.
Yes. Hi, Yogesh.
Not so good.